I apologize. I have just a brief issue that I'm going to ask our courts officer.
Yes.
Pat, I have go live on YouTube clicked.
The
And
blue go
when
live button.
The blue go live button is clicked.
Mhm.
And when I go to more, I don't have the option live on custom streaming service.
For the first instance only, we just press the blue button. So,
Oh, got it. Oh, okay. All right. So we have been live. I apologize. I'm going to start the recording.
Okay, these things happen.
I'm going to start the recording now. Okay. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you and good morning. Before we commence, I would like to take a few moments to honor Supreme Judicial Court Chief Justice Ralph Gantz, who died suddenly at his home yesterday. All of us, including Justice Mary Sullivan and Justice John Englander, who join me on today's panel, are deeply saddened by this tragic news. Chief Justice Gantz was known for his fairness, his moral compass, his incredible work ethic, and above all, his kindness. He was truly a great man and a brilliant jurist. His legacy as Chief Justice, as the Associate Justice of the Supreme Judicial Court, and as a judge of the Superior Court is profound. He was a public servant of the highest order, and he was a leader, a true leader, one who treated everyone with dignity and respect. Our hearts and prayers are with his family first and foremost. Also with his colleagues, his fellow justices on the Supreme Judicial Court, and with every member of the judiciary in Massachusetts and all of those who worked closely with it. He was a friend to us all, and he will be sorely missed. And I'm going to ask all of you to join me in a moment of silence in his honor. Thank you all very much. And now we will turn to our business at hand today, and I will call the first case, which is case number 2019-1211, Commonwealth versus PARKPOOM Sanskrit. A few preliminary comments regarding today's sitting. I've already introduced the panel to you. I would like to thank the members of the appeals court who have made our virtual sittings possible. During the course of today's argument, we may experience some technical difficulties. If so, we ask for your patience. And just a reminder that the rules of appellate procedure apply here, just as if we were in the normal courtroom. Each side has 15 minutes to present their argument. There is no rebuttal, and you can be confident that the panel has read everything that you have submitted to. So with that said, I believe Attorney Power, you're up first. Please begin.
Thank you, Your Honor, and good morning. Andrew Power for PARKPOOM SEESANGRIT. Now, the theory of defense in this case was that no crime was committed, that my client was providing perineal care to an incontinent dementia patient, that the patient did not allege any misconduct, and that my client's attempts to explain what he had been doing were misconstrued by the police officer during the interrogation. Now here, post-conviction, we have shown that counsel was ineffective in failing to investigate and develop this defense for a period of about 3 years. Now I'm going to begin with the fact that there was no explanation of the perineal care process in a case where perineal care was a central theory of defense. Now we have produced information and diagrams post-conviction on what perineal care actually is. Now the Red Cross CNA textbook in the record shows that perineal care involves contact with the first joint of the fingers and all genital surfaces. Now penetration is legally defined as any contact with any part of the genitalia. So 1 inch of penetration would be consistent with perineal care.
Well, wait, counsel, if I might stop you for a moment. Is there anything that says that inserting fingers into the vagina 1 inch is consistent with perineal care?
Yes.
Where?
The diagram in the Red Cross CNA textbook that we've reproduced. Now, the verb inserting is a little tricky, but what we're talking about is penetration, the legal definition of penetration.
No, you're talking about penetration. I'm talking about the evidence that was actually in, which I understood to involve insertion. Am I misunderstanding what he said during the videotape?
Yes, you are misunderstanding. Judge Sweeney found that there was 1 inch of contact, 1 inch, which means the length of about a fingertip, from the tip of the finger to the first joint. Now, during the interrogation, he was asked he showed the officer what he meant, 1 inch, and he pointed to the first joint of his finger. Now, the officer said up to the knuckle. Now, Judge Sweeney, reviewing that evidence, said that was not what he meant. The officer was misconstruing his statement. It was not penetration up to the knuckle. It was simply 1 inch of penetration, a fingertip's length of penetration. Now, if you look at the diagram that we provided,
I'm sorry, when you say Judge Sweeney said that, do you mean Judge Sweeney said that in her ruling on the motion for new trial?
Yes.
Okay, because she didn't say that at the time that she found him guilty, right?
Correct.
And his statement to the officer, yes, I put my fingers inside her vagina. That was one of several times when he said that.
I would disagree with that, Your Honor. He said it one time. And we have to also analyze, and part of the ineffectiveness question here is that trial counsel failed to develop expert testimony about interrogative suggestibility. Now, at the point that my client said, yes, I put my fingers inside her, the officer had used the phrase vagina 11 times, often in combination with the words your fingers and inside her. Overall, the officer repeated the word vagina 22 times. Now, my client used it once, that one time. He never used it again. He never said that again. And the verdict, according to Judge Sweeney, rested entirely on that purported admission. Now, if we're going to rest the verdict, if we're going to say that, okay, he said he put his fingers in her vagina, let's talk about interrogative suggestibility. Let's talk about interrogative pressure, because counsel did not talk about it.
You for a moment. Don't we need to also talk about the circumstances and the other evidence that was presented to the judge as a fact finder in this case?
At trial or post-conviction, Your Honor?
Well, I'm referring to actually the trial, because I think I just heard you say that Judge Sweeney relied enormously on, or primarily on, what I think your words were, on your client's admission. But actually, I think that as a fact finder, there was other evidence that also could have been, that was likely relied on by the judge to determine guilt in this case. Number one being the fact that the position of the victim when she was discovered by the other nurse, when your client was with her, and the fact that he immediately indicated that he was changing her diaper because, or her pull-up, because it was wet when it was not. Isn't that evidence that the judge could have relied on that would be sufficient even without the conversation, the discussion rather, that you're presenting to us with respect to the admission itself?
Well, regarding sufficiency of the evidence, that's one issue. But if we're talking about ineffective assistance of counsel, we're talking about evidence that could have made a difference to a rational jury if it had been presented by trial counsel. So yes, the fact finder heard that the brief was dry and odorless. Of course, the Commonwealth didn't prove that he didn't detect an odor before he cleaned her. The evidence shows no odor after he cleaned her, but no one spoke to the alleged victim's CNA about prior odor. But in any event, there was evidence that the brief was dry, and the brief, the nurse said she didn't detect an odor on the brief afterwards. However, if we're looking at what trial counsel presented and what trial counsel failed to present, the question has to be, would this have made a difference, to a rational jury considering the totality of the evidence? If they had heard testimony about interrogative pressure, about interrogative.
Well, my point is that since there was other compelling circumstantial evidence, how much of a difference would it have made if the line of defense that you're suggesting, that you're talking about now, and that was brought up in the motion for new trial, had been introduced?
Well, I'd like to know.
Judge Sweeney is a very accomplished Superior Court judge. Just before her retirement, after years on the bench, said in a written memorandum decision that it would not have made a difference.
Absolutely. And that also goes to the strength of the evidence. The fact that the brief was dry goes to the question of what element of the crime does this show? Now, the first element of rape is sexual intercourse. And sexual intercourse is defined as penetration regardless of degree. Now, perineal care requires penetration. At what point does perineal care become sexual intercourse? So even with a negligent care or unnecessary perineal care, there's no warning in the case law or textbook that, taking off a dry brief, if the odor's not strong, it's not perineal care anymore. This is sexual intercourse.
No,
put my client on notice?
Maybe it's when, excuse me just for a moment, maybe it's when you are taking care of a female patient who is lying in, not in her own room, but in the bed of another male patient where she's not supposed to be, and doing so behind a closed curtain, and immediately recognizing I'm in trouble because of what I'm doing. It seems to me that those are kinds of behaviors for which there doesn't need to be any kind of legislative notice that you are doing something that's incorrect.
Well, the evidence was that the patient wandered into that room by herself. Now, the CNA textbook shows that if you are changing a patient, if you're changing a patient's brief, you should close the privacy curtain so the other people in the room don't see the patient undressed. And as to the rule against touching female patients in that facility, I would argue that that rule is discriminatory and should be disregarded by this court because it's unrelated to occupational qualifications. This was not a battered women's shelter. What if the rule was that he wasn't supposed to touch white patients? It's clearly discriminatory. Cross-gender care is legal.
That's not the rule. And the point is that he was aware of the rule and took it upon himself not to follow it. There was no evidence as to why that rule was in place. And so I don't think it's appropriate for us to be able to engage in discussion if it's discriminatory or not, without any evidence as to why that rule was there and for what reason the institution felt it was necessary. Your client didn't agree with it, and he said so right from the very beginning, even during his police interview, as I recall, correct?
Yes.
Yeah, so that was apparent to the fact finder from the very beginning.
Right, but the fact is that cross-gender care is legal. It's accepted. It was done at this facility. Female CNAs took care of male patients. And it was the accusation the suspicion of a male caregiver was based on the unfair sexualization of male caregivers. And that, as Nurse Koziol said, was the basis of the accusation. She didn't actually see any misconduct. If you look at all the other cases, there's some sort of indication that the CNA or the doctor is having sex with the patient. In this case, Nurse Koziol simply said, I suspected that he was doing something because male patients aren't supposed to take care of the females.
Well, it was a
Now-
little bit more than that.
Yeah.
When he came out from behind the curtain, he behaved in a way that she thought he was hiding something. And that's what her testimony indicated. And that's part of the reason, at least, that she spoke to her supervisor. Can I ask you, where will I find the Red Cross document that you rely on in the record? It was submitted with the motion for new trial, is that right?
Yes, it was, Your Honor.
What was it attached to?
It's in the record appendix.
Was it attached to somebody's affidavit?
No, it wasn't attached to an affidavit. We weren't allowed to provide, we weren't given funds for an expert. So we submitted the Red Cross training manual freestanding. It's also available publicly in libraries and online.
And it's submitted as a authoritative treatise then, right?
Yes.
Yeah, so I see here that you have it, you've characterized that or just explained it as excerpts in your table of contents, correct?
I have provided excerpts from it in the table of contents. Of course, it's available online and I believe is a publicly
Your
available research
representation
document.
earlier was that if I read that manual, I'm going to see that it indicates that in doing perineal care, you insert your finger into the vagina?
Yes, in doing perineal care,
Because you didn't put that in your brief, and it was a question that was on my mind when I came in here today.
it was
You
in
have, you have the
brief, I
excerpt that you rely upon right now that you could read to me?
It's at page 35 of the record appendix. Skill 1311, providing perineal care. Now, as Judge Sweeney stated, there was some confusion because my client is not a native English speaker, and also because in common parlance, vagina refers not only to the internal organ, but also to the external vulva. So Judge Sweeney found, and I agree, that they were likely talking about penetration of the vulva, not penetration of the interior organ, the vagina.
Where did she find that?
In her post-conviction,
nor do I recall that as being a finding, counsel. What are you talking about now?
in her denial of the motion for new trial, Judge Sweeney states, I'm going to try and find it for you here. At page 85 of the record appendix, whether Ingalls and defendant had the same understanding of the word vagina to include vulva as the defendant claims he understands it in Thai does not alter the outcome, because in any event, the defendant unequivocally told Ingalls that he inserted his 2 fingers 1 inch into some part of the victim's genitalia. That evidence is sufficient to support the guilty finding. And then she cites Commonwealth versus Moniz, which is an inapposite case because Moniz was convicted of penetrating the vagina of his girlfriend's 6-year-old daughter. That case has nothing to do with medical care. It has nothing to do with certified nurse assistants or nursing care.
You said it's page 35. Is that of the supplemental appendix?
Page 85 of the record
No, I'm
appendix.
talking about the Red Cross thing.
Oh, the Red Cross thing is at page 35 of the record appendix.
And where
Providing
on that
perineal
page,
care.
where on that page does it say that one would insert their 2 fingers and 1 inch into the female patient's vagina?
First of all, my client didn't use the word insert. He said, I put my fingers inside her vagina. After Officer Ingalls had said, did you put your fingers inside her vagina about 11 times?
But
Now,
of
what you
course,
can
now
see is that
here we're
there is,
supposed to have gloves and a washcloth as well if you're following this particular procedure.
yes,
Which
and now
wasn't,
at the nursing home, they didn't use gloves, as one of the nurses explained. They used paper wipes. Now, my client stated on the video that he was wearing gloves. Gloves and tissues were found at the scene. Now, the no gloves testimony was elicited by trial counsel 3 years after the incident. So if gloves are a significant factor in your decision, I would argue I would add that to the list of things in which trial counsel was ineffective. In this case, for eliciting contradictory testimony, which indicated that she hadn't reviewed the video before asking the question.
I see your time has expired. I'm just going to check with the panel to see if they have any further questions that they'd like to have answered. And I am seeing none. Thank you very much for your argument. We appreciate it.
Thank you,
And
Your
now
Honor.
to Attorney Kohler.
Thank you, Your Honor. May it please the court, Carrie Kohler for the Commonwealth. I would begin, Your Honors, by stating that with respect to the defendant's claim that 22B is void for vagueness, that the facts here really speak for themselves. As I outlined in my brief, and Your Honor, Judge Vuono mentioned, separate and apart from any physical blemishes that were observed on the victim, there was also significant circumstantial evidence to prove that the defendant raped the dementia patient. Particularly, I would suggest that when Attorney Kozel, I'm not sure how to pronounce it, appeared and the defendant came back from behind the curtain, she told him directly that it looks really bad for you, that she thought he was doing something wrong. And if my recollection is correct, her initial belief was that he was playing on his cell phone or doing something that was not permitted. So I would say that
this part of the evidence is troublesome because the most of it shows is consciousness of guilt, right? And it seems as the standard jury instruction of consciousness of guilt always says, there could be a perfectly innocent reason for someone's reaction. And here the defendant himself says, I knew I was violating a rule of the institution, that this particular institution did not allow me to provide this type of care to a female patient. And so basically he said from the very beginning, that's why I reacted that way. And in fact, if you were working 70 hours a week and you needed your job and you did something against the rules, you might very well be upset and show that, right?
Sure.
So what do we do with that?
Well, I think it's a credibility call, essentially, at that point, what the correct explanation for it is. And Judge Sweeney didn't credit that he was providing medical care to the victim, even setting aside the evidence that he wasn't allowed to provide her medical care. And I'd suggest that there isn't credible evidence in the light most favorable to the Commonwealth that he was providing any sort of hygienic medical procedure.
Oh, wait a second. Hold on. This is where I lose you. I'm reading page 35 of the Red Cross document. And so my first question for you is, if someone did what is described there, would that constitute rape under Massachusetts law?
No, Your Honor, I don't believe that it would. Well, there's no case directly on point that defines clearly what's a medical procedure, what's rape, what's penetration. The case law is a bit more amorphous than that. But I cited to several cases in my brief that discuss how the issue of consent is at play where medical care is involved in allegations of rape. Now,
so let me make sure I understand what you're saying, though, because you're saying to me what's on page 35 would not constitute rape because the person to whom that care is being given consented, and that's the only reason.
Well, I think there's two reasons in this particular case. If you go, I think in reading this article or portion of the textbook, that the wiping of the external genitalia may not necessarily be penetration. But if we assume
I tell you that I've seen some case law in the last couple of years, and this doesn't just say external. I mean, it doesn't. It's very graphic.
If we assume that it is in fact penetration, the case is escaping me right now, but I did cite to it in my brief where there was
She's not capable of consent, right? She's got dementia.
Mhm.
So what separates the behavior of someone who is following the medical procedures that are supposed to take place from being charged with rape?
Well, I think in the circumstances of medical care being lawfully provided, which the Commonwealth doesn't yield was done in this case. That's not the facts we have before us. But I think in the circumstances,
that's my next set of questions, counsel, because I'm gonna need to understand how we know that and how the Commonwealth proved that, if in fact that's part of your burden of proof.
I think with respect to the first issue, how does somebody provide medical care and not commit rape? I'd suggest that the cases that I cited to explain that when there is a bona fide medical care, there are other indicia of consent. And in this particular case, there was evidence, some of it direct, some of it that can be readily inferred, that the victim was at the nursing home to be provided care by medical practitioners, that her family had placed her there, her husband in particular was mentioned, to be taken care of, and that they consented to her being bathed, her being dressed, her being cared for. I would suggest that in the circumstances, there can be consent inferred for that medical care. In this defendant's case, the defendant was not authorized to provide her the kind of care that he's alleging now post-conviction and also during trial that he was. I submit that he wasn't cleaning her. There wasn't evidence he was cleaning her. His hands weren't gloved as you're supposed to, which he indicated in his interview, and there was evidence of gloves, so that was a point of contention there. But I would submit that there isn't evidence that he was trying to clean her. The evidence is that he was inserting his fingers into her vagina up to the first knuckle for its own sake.
Well, you presented evidence that he was cleaning her in your affirmative case. So I don't understand how you can say there was not evidence he was cleaning her. Didn't you present the videotape in your affirmative case?
The video interview, Your Honor?
Yes.
Yes.
And he said, I was cleaning her. So there was evidence that he was cleaning her as part of your affirmative case.
There was evidence that he made that statement, which Her Honor, Judge Sweeney could have credited or not. It was the Commonwealth's theory at trial that was a lie and he wasn't cleaning her. That was part of his essentially story, for lack of a better term, to law enforcement to explain why he was behind a privacy curtain with a female patient that he shouldn't have been with, where her genitalia was.
The only evidence that of rape was in the same video. All the other circumstantial evidence does not show rape.
If I may, with respect to the interview, excuse me though, John, Judge Englander didn't get an answer to that last question, if you'd like to respond.
I'm sorry, Your Honor, I would respond that the video was an entire statement, which Her Honor, as the fact finder, was free to credit completely, not at all, or in part. And I'd submit that from Her Honor's rulings, both on the post-conviction motions for funds and on the motion for new trial, that Her Honor explained that she credited some of it and she did not credit other portions of it, if I'm answering Your Honor's question.
Then with respect to that interview, I'm looking at pages 33 and 34 of the transcript, which are at pages 95 and 96 to 97. Did this come in the videotape, the description of the prior incident in the bathroom?
Is Your Honor referring to the pages of the defendant's brief?
No, I'm referring to the transcript of the witness interview, where he is asked if he has ever done this before, and he says no on several occasions, and then he acknowledges that he was in a bathroom with her where he did this on another occasion.
Yes, Your
And
Honor.
did that come, was that portion of the video played for the fact finder?
Your Honor, I believe the entire video came in.
All right.
And I don't believe it was played in open court. I believe Her Honor watched it in her lobby.
Okay. So in that segment of the interview, he's asked a couple of different times if he'd done it before, and he says no. And then he acknowledges that on another occasion, he was wiping her at the toilet as she stood. And then on that occasion as well, he discarded the paper and inserted his fingers, if you were to give it in the light, his version of events, into her vulva to clean it. And she said, she told him to stop. In your view, if it was his, just so we know where the boundary is between cleaning and rape, if we were to accept that version of events, that he was literally putting his finger into her vulva to quote unquote clean it, is that a sexual assault? If it does not comport with the Red Cross manual, because I don't see anything in the Red Cross manuals that says that's how you clean somebody.
I would submit that it is. That's using a bona fide hygienic procedure as a guise to commit a sexual assault. And that's the Commonwealth's theory. It was the Commonwealth's theory at trial that this was a guise. And I'd submit that that's...
Does it even have to be a guise? Let's say he was just doing it. Let's say he said, I thought I should put my finger 1 inch up into her vagina in order to clean her. Whether it's vulva or vagina, is that a sexual assault?
I'd submit that it is, Your Honor. I'd submit that there's no justification or excuse for such a touching. And I know that's not exactly how we discuss 22B, but I would submit that in this case, the defendant's essentially trying to have it both ways. He's saying he wasn't on notice and he couldn't possibly have understood that what he did was wrong and that it was rape. He was also and is incredibly bright. As Officer Ingalls pointed out, he's a 4.0 GPA. At the time of trial, he was working as an electrical engineer, incredibly accomplished, multiple degrees.
Some kind of line that is understandable and not on a razor's edge between a lawful medical procedure and something that's going to send someone to jail for 10 to 12 years? I mean, it seems to me we're being awfully cavalier around a very complicated problem, aren't we? I mean, you know, you have medical providers who are performing these services for people daily. And the only manual that I have, and it wasn't submitted in evidence at trial, it suggests that the behavior could at least qualify as penetration under our laws. And so then we're left with charging someone with rape because of someone's perception of the circumstances under which it occurred?
Your Honor, I would disagree with the court's description that it's on a razor edge. I would submit that it was clear what the defendant was allowed to do and to not do, and that in the cases where it's
What the defendant was allowed to do and to not do in what respect? Are you now talking about the rules of his particular hospital, or are you talking about our law of rape?
I'm talking about the laws of the particular hospital and our laws. He wasn't.
Surely we don't define rape based on the rules of his particular hospital.
No,
That
I do. I mean, with respect to what he was allowed to do. He wasn't legally allowed to insert his fingers up to the first knuckle because that was rape. And he wasn't allowed to clean a female patient's genitalia. They're separate. They're not both legally significant, but I'd submit they're factually significant. The defendant was on notice he shouldn't have been doing what he was doing for multiple reasons. And I would say with respect to—
I think it's factually significant only in the sense that perhaps it suggests, and I think that, or that it suggests that he was doing something that he knew he shouldn't be doing. And beyond that, I'm not sure what you get from that. It is not part of the definition of rape, surely. Surely we aren't going to adopt a rule that says that a male CNA can't care for a female CNA as a matter of Massachusetts law.
Of course not, and that's not my suggestion.
Okay, for a female patient, I misspoke.
Well, my understanding of your argument, counsel, is you're saying there was no consent because of the way the rules of the institution were written.
I would submit that, and I would also submit there wasn't actual consent. In both circumstances we've talked about, that episode Your Honor indicated on page 96, the victim said stop. And in the facts at issue here, she said it hurt. And the defendant reported what she said to Officer Ingalls. So consent, as far as medical care, was non-existent because of the rules of the facility, and consent actually was presented to the judge.
Was there any evidence that the victim knew, or that anybody who could consent on behalf of the victim knew about the rules of the facility with respect to males or females being able to provide care?
There wasn't any direct evidence in the record on that.
There's no, that's, I don't understand how that the rule can be relevant to her consent if there's no evidence with respect to her, whatever consent there may have been. I mean, the Commonwealth did not have an expert witness on what perineal care involves. There was no such evidence. Am I right about that?
Your Honor, I would disagree, because both nurses had experience in perineal care and they were cross-examined extensively about how that was done.
Was there testimony from either of the nurses, and I apologize, I should know this, I don't recall seeing it in the briefs. Was there testimony from either of the nurses that you do not put your fingers inside the vagina?
Yes, Your Honor. I believe it was Nurse Kojal who said that she had never, and I believe that Nurse Gunther, I'm not sure, testified inconsistently with that and said that it may happen. The nurses had different points of how to conduct the care, and it wasn't consistent all the way.
Okay, I apologize, Judge Vuono. I know the time is up, but there's another issue here. If I
Go ahead.
It's a complicated case. What is the reason that the Commonwealth, why was the DNA evidence relevant and appropriately introduced in this case?
Your Honor, I would submit that it was an attempt to do more than what was allowed. So what actually happened at trial was Her Honor Judge Sweeney heard from both parties, limited the use of the DNA instruction, and the only function it had at trial was to suggest to the fact finder that the defendant could not be excluded as a contributing party to the DNA that was collected from the pull-up. And I would submit Her Honor did not use any of that evidence in reaching her verdict.
We don't know that. All we know is what she said after the fact. Why was it important to put in DNA evidence to show that he couldn't be excluded from what had touched the pull-up, when he admitted freely that he is the one who removed the pull-up and put it on the floor? There was no issue with respect to that, was there?
No, I believe he threw it.
someone who, perhaps has maybe a little bit of a cynic's view of this might think that the reason for putting in that DNA evidence was because there were 3 of his sperm cells found.
Yes, and I believe
Is
that's
there any
what
evidence put in as to the importance of 3 sperm cells?
I believe the intent of the prosecutor was to put in that evidence and make a connection
And he
to
did,
some sort
right?
of.
In closing argument, he did. He suggested that showed that there was something sexual in what was done.
Yes, Your Honor, that was his intent.
Is your
but-
argument that it's nevertheless harmless error under the circumstances if we were to conclude that evidence should have been excluded as a matter of discretion? Is it still going to be your argument that evidence was harmless error because of what the judge said a year later?
I think it has to be. I don't think I could discredit what Her Honor Judge Sweeney said, as she was I don't think that Judge Sweeney misconstrued it in finding that. And I would suggest that she was critical of both parties in their conduct, both the Commonwealth and defense counsel. I think the court has to. I think there is a special deference that this panel owes Judge Sweeney with respect to those particular rulings and findings.
Is there any case law that tells us that? Because I would think that if we're going to understand what the judge's thinking was, it wouldn't necessarily come after she's seen what the criticism is of the trial, but rather it should come contemporaneously with the ruling that we're worried about.
In other words, I'm just going to add to that in other words, if it was not a jury waived trial, there'd be no way of knowing what kind of impact that evidence would have had on the jury, because of course the jury does not give a written explanation of why they did not find a certain way.
I would agree that I know I cited it in my brief and I quoted special deference to the trial judge. I can't seem to locate it right now. And I would agree with Your Honor that it's impossible to know what the jury's thinking is. I would say that the defendant stands in a different position here. We do know what Her Honor thought. We know what Her Honor thought in great detail with respect to both the prosecuting attorney and defense counsel, and that she was critical of both performances. And
Correct. But I think Justice Englander's point is that yes, in terms of the motion for new trial, but is that an accurate reflection? Could it possibly be, not that we don't have any faith in Justice Sweeney, but could it possibly be an appropriate and accurate reflection of what influenced her to find this individual guilty at the time, more than a year earlier?
I think it has to be, Your Honor. I think that she was in the best position to tell us what she thought. I don't know how we could discern that her memory is inaccurate, especially where it was so detailed and particular.
Okay, you've answered my question. Justice Englander, have you had your time? And Justice Sullivan? Yes. Thank you both very much. I think Justice Englander was really on target when he said this is a complicated case. I can assure you we'll take it very seriously, and we'll get an answer back to you as soon as we can. So thank you both very much. Good morning. Let me begin by introducing the panel to you. Joining me today is Justice Mary Sullivan and Justice John Englander. My name is Ariana Vuono. I wanted to inform you both that at the beginning of today's session, we paid tribute to Chief Justice Ralph Gantz, and we observed a moment of silence. Given our virtual platform, we could not include everybody in that, and not everybody could participate. So I just want to say that, of course, his loss is on our minds as we continue on today. I'm going to call the next case, 2019-1215, Commonwealth versus Amy DAIGLE, or DAIGLE. I'll find out soon enough. And just a few preliminary comments before we begin. I want to thank the members of the appeals court for making our virtual sittings possible. During the course of your arguments, we may experience some technical difficulties, and so we'll ask for your patience. Just a reminder that the rules of appellate procedure apply to this platform as if we were in the courtroom. Each side has 15 minutes to present your argument. There is no rebuttal, and you can feel confident that the panel has read everything that you have submitted to us for consideration today. With those remarks concluded, Attorney Content, please begin your argument.
Thank you. If it pleases the court, justices of the appeals court, my name is Attorney Michael Contant. I represent the defendant appellant Amy Daigle with this for her appeal, this OUI conviction out of the Newburyport District Court. If just to start off, I'd like to jump right to our second issue of the matter, and it actually really also relates to the third, which was the testimony both on cross-examination and then of the defendant, as well as direct of the officer, and then ultimately the admission of the OUI statutory rights and consent form. In this particular case, the ADA brought this form to the court's attention with the intention of both cross-examining the defendant first with it. She argued to Judge Swan that the defendant had opened the door because Ms. Daigle, as the court may recall through the facts, had asked repeatedly after not being able to complete the breath test to have another chance at it. She wanted to prove her innocence by blowing into the machine again. The ADA argued that she said something to the effect that she would do anything to prove her innocence. That is not borne out by the actual testimony in the transcripts and in the record. Ms. Daigle was simply saying, I would like to take the breath test again. The Commonwealth was allowed.
But she did testify, just to be clear, that she did testify that she did say to the jury that she wanted to prove her innocence, correct? She
did make that statement, but it was in the context, the repeated context of taking an additional breath test in order to prove her innocence. It wasn't, I'll do anything as argued by the ADA in this matter, which was what was argued to Judge Swan. Ultimately, Judge Swan allowed the admission, allowed the cross-examination first of Ms. Daigle, and it was a tedious cross-examination that went through many of the rights, including Ms. Daigle's right to have a blood draw, a doctor exam and a blood draw, as noted on this particular form. The DA, the DA made this, issue 2 deals with, she said, well, the defendant opened the door to this. I submit to the court that this falls under what they call the doctrine of curative admissibility under Martin, which is the most relevant case on this. In order to get it in under this standard, the evidence has to be inadmissible, and also to cause the Commonwealth, in this case, significant prejudice. I submit to the court that neither is present in this particular case. The evidence wasn't, of course, admissible and proper. Ms. Daigle was being, cross-examined concerning her inability to take the test. It was being put forth both through the motion to eliminate argument as well as in the testimony itself, in the argument itself, that Ms. Daigle essentially had a consciousness of guilt, was avoiding the test, and that's why it was being done.
Counsel, if I might, counsel, is your argument, so she took the stand, right?
Yes,
and
sir.
She then is subject to any reasonable cross-examination that flows from her testimony, right?
Yes.
And if she says, I wanted to prove my innocence, is it your argument that it is the Commonwealth cannot respond to that by suggesting other ways in which she could have proved her innocence?
In this instance, Justice, I don't believe they could have. Her testimony, specifically under this doctrine.
403. I'm trying to understand what rule of evidence are you making this argument under, and also what is our standard of review?
Certainly, it was objected to, so the standard review would be error, I believe, Your Honor. However, the rule of evidence is the doctrine of curative admissibility. The ADA argued to the judge, and the judge allowed it, saying that Ms. Daigle had opened the door to this evidence by saying that she wanted to prove her innocence by taking another breath test, and it was limited to that. And so she was doing so in response to the DA's challenge, basically rebutting the DA's challenge that she was essentially avoiding the test or consciousness of guilt. It also can be allowed by explaining the situation, explaining her actions, because the DA also argued that she was had an angry reaction at the police station, which as most
counsel, I really doctrine of curative disability. I'm stuck on the notion.
Admissibility. So that's the evidentiary doctrine.
Hold on. Your client is on the stand. She's testifying.
Yes.
Any reasonable cross-examination relating to what she says is fair game, no?
I don't disagree that reasonable cross-examination is, but what the Commonwealth did, and this sort of dovetails into our next issue, is that they brought forth Ms. Daigle's ability given to her under that statutory rights to go get a medical exam, which she was under no obligation to do. It's an option, but it's not a requirement. And in order to say that Ms. Daigle opened the door to this under this particular doctrine, which is cited in my brief, and specifically the 2009 case of Commonwealth versus Martin, there's two requirements. The first is that the testimony of Ms. Daigle in this case, or evidence in this case, had to be inadmissible. I'm submitting to the court that the evidence was in fact admissible. So this doctrine's opening of the door never came to pass. The Commonwealth cites in the briefs.
I've completely lost you, and I think it's because you're relying on some case law that it doesn't seem to me is where I would go. I mean, your client says, I want to prove my innocence. And the reaction to that from the Commonwealth is, well, you were aware of other ways that you could do that.
Well, she didn't.
Or those.
She said she wanted to take the breath test again to prove her innocence. She didn't mention any other means. She didn't mention the breath, a blood draw, or anything like that.
Whether she did or she didn't, why is that unfair response from the Commonwealth to say there were other ways that you could have proved your innocence?
Well, she was questioned specifically concerning a right, and this dovetails, I might as well just jump into the next argument, is that the Commonwealth improperly shifts the burden to Ms. Daigle. She's given the statutory rights, and she has the option of presenting this evidence. She's under absolutely no obligation to do so. And when the Commonwealth's not allowed to shift the burden of the presumption of innocence over to the defendant to affirmatively bring forth evidence, and when they signal to the jury that there's this other evidence out there that she could have gotten, she could have brought this witness or other evidence, that they are shifting that particular burden over to Ms. Daigle, over to the defendant, because they're signaling to the jury that she could have gone and done this, even though she was under no obligation to do so, and brought it to your attention, and that she had some duty to do so. And that's what the ADA did in this case. I do believe it wasn't admissible in the first place under that doctrine. Well, I'll move on from there because it doesn't seem to be registered.
Are you saying, would it have been different had there been a limiting, would it have been a different situation in your view if there had been a limiting instruction with respect to how the jury could view the evidence of the right to take a blood test or have a doctor called, et cetera, et cetera?
My understanding is there was no limiting instruction in this case, but
Right.
I don't think it would be a difference in this case either, simply because we're talking about now the jury's been put on alert that Ms. Daigle, and tediously, it wasn't a single mention. It was mentioned through a tedious cross-examination. The form was introduced to the officer. The jury had that back in the room, that she had all these other things that she could have done. And the inference, the clear inference, was that she could have done this stuff and she should have brought it if she really wanted to prove her innocence, which shifts the burden to Ms. Daigle, which is inappropriate under the Constitution.
Well, but wait a second.
I'd like to take this back a step.
Sure.
to the test itself.
Mhm.
And there's indication in the transcript that this trial took place at a time when, had a sample been given, breathalyzer tests were not being admitted. Is that correct?
That is correct, and defense counsel argued that during the motion to eliminate as well. So.
All right. So there was, shall we say, a fairly widespread concern in the trial court at that point regarding the reliability of the tests.
That would be an understatement, yes.
Yes, okay. And I'm going to ask you a question, and I'm going to ask counsel for the Commonwealth to answer the same one. The only evidence that I saw in the record of the qualifications of the officer who conducted it, or was the following question on page 82 of the transcript: were you trained to detect or investigate operating under the influence cases? Yes, I was. Was there any other testimony regarding the officer's qualifications or the machine that was used on that day?
No, Justice, there was not. In fact, that it did argue as a sub-argument to a number one. There was nothing concerning the officer's particular extensive training related to the machine, his certification on the machine, whether the machine went through periodic testing or the annual certification procedure. Those are all prerequisites under Barbeau to bringing this, even bringing this to light. And the officer ultimately did testify in front of the jury that it was a failure. He used the word failure in quote, that's actual quotation. And I would argue, in fact, that that was of some prejudice because the jury took note of that. The jury and their questions connected with that.
There was a question on that. Have we any cases, or are there any cases outside of this jurisdiction arising in the refusal context which discuss the qualifications of the operator or the reliability of the breathalyzer itself? We have plenty of case law in the Commonwealth about what happens when a sample is given.
Right.
Have you any case law for us, either in this jurisdiction or outside of it, in a refusal context?
I could not find any in this particular context, but the way it was presented to the jury by Officer Jenkins was that after watching the machine and not Ms. Daigle, there wasn't enough air going in the machine, and after 3 attempts, he deemed that a failure. That was, and he said, and it was acknowledged that it was the officer's opinion that it was a failure. So
Well, actually, the officer explained that the machine gives you 3 times, and after that, the machine resets. So, in fairness to the testimony that the jury heard, that's what the machine does. He wasn't very to give any detailed explanation about it. He could have gone a step further and explained that you only get 3 times on the machine, that's it. But he did say that the machine resets after 3 times.
That was the explanation, but the word failure was used, I believe it was at 109 or 110, Justice, of transcript 1.
Well, he first said it was a refusal that was stricken, and then he was asked if that was a failure, and he said that's correct. Right. But it's clear that his understanding was kind of a 3 strikes and you're out.
I believe so. I believe so, yes. And that sort of brings us to the other issue under Curley. And while Curley does say once you consent to the test, the physical actions, a series of physical actions that follow are admissible, I'd submit in this case it is factually distinct. Under Curley and under
because
Ando
nobody
Soto,
was watching her at the time.
Correct. Under both Ando Soto and Curley, the person was, for lack of a better term, messing around. They weren't following instructions, or they were blowing with their mouth open, as I recall. In Curley, I think the gentleman at the hospital was talking to a friend and said, "Hey, I pulled a fast one here." So under those circumstances, I do believe it is factually distinct from Curley, Ando Soto, and all the progeny that comes down thereafter. So,
well, I'd like to separate out your 2 arguments for a moment. If hypothetically there hadn't been evidence of the refusal, but we still had the statement, "I want to prove my innocence," I understand that you feel it was inappropriate to admit the consent form, but does the consent form, given that statement, have significance independent of the refusal itself? In other words, if the refusal didn't come in, does the consent form come in?
No, it doesn't, because without the refusal, Ms. Daigle wouldn't have been talking about on her direct examination her attempts to use the machine, why she wanted another shot at the machine, why she was upset and angry, which was in rebuttal to the officer's testimony about her demeanor. Went back at the station. We never would have got there, basically.
All right. So your position is they're intertwined.
I believe so.
Your time is almost up. I want to see if the panel has any questions, and then give you a few seconds now to sum up.
Just in summary, I do believe there's some merit in all 3 or really 4 of the issues here. I do believe it's the significance of particularly, again, bringing in evidence concerning that statutory rights and consent form is particularly damning, as it puts an obligation on the defendant to do something they would not have otherwise needed to do. such as get a blood test, even though that is their option. It's not a requirement. And therefore, again, like I said, the burden shifts, and I also think it wasn't admissible. With that, I would defer the rest of my time and ask the panel to just review our brief in full. Thank you very much. Appreciate your time.
Well, thank you. Thank you very much. All right, Attorney Mello.
May it please the court, Emily Mello on behalf of the Commonwealth. I'd like to I'll start also with that second issue. The Commonwealth does not.
Actually, if you don't mind, could you start with the first issue?
Of course.
Which was, as I understand it, was kicked off by a motion in limine. The Commonwealth decided that because there was going to be an expert witness on behalf of the defendant, that the Commonwealth wanted to put in their affirmative case that she had attempted the breathalyzer and that it had not been successful, right?
Yes, the Commonwealth wanted to admit that she had attempted the breathalyzer and had not been successful.
What is the foundation that the Commonwealth laid for Officer Jenkins being able to testify that it was an unsuccessful breathalyzer test?
Well, the officer testified, and this is really the only way that an officer would know that it was an unsuccessful attempt, is by looking at the instrument and seeing the screen, and it shows that there's an insufficient breath sample. So there isn't really
that the machine worked.
Well, there wasn't. I would say that, first of all, you didn't have to set the foundational requirements for admitting a BT test because there was no actual BT
sure,
test.
but if you want to put in evidence that something happened with that machine, it sure seems to me you've got to lay some kind of foundation that the machine works.
Well, certainly in Soto and in Curley, they say that all that is required for putting in this evidence that the defendant was attempting to take a test and not actually successfully taking it is her consent, because it's an Article 12 issue and the consent vitiates that Article 12.
Well, I don't see how you can read either one of those cases as saying that if you want to put in evidence, this is essentially scientific evidence. He's not looking at her. In Curley, the officer was actually viewing the person trying to take the test. In this case, Officer Jenkins is not looking at her. He's looking at the machine and he's testifying as to what the machine reading was, right?
He's testifying that he sees on the screen that it's an insufficient breath sample.
You explain to me if I'm wrong. It seems to me he's putting in scientific evidence. And if he's putting in scientific evidence, he has to lay a foundation with respect to why it is that he thinks the machine was working, doesn't he?
I would respectfully disagree. And I would also state that were that foundation to be put in, that foundation would actually include the statutory rights and consent form. So it kind of goes against the grain of the second issue.
Let's leave the step. Go ahead, Judge Vuono.
How is that? Why would that be the case?
Because in order to put in a breath test, there's 5 requirements and there are 3 documents that you must put in.
But at the point here is, I think, is slightly different, and that is the BT test. A BT test was not accomplished successfully, and so that series of questions were not asked, etc. But the Commonwealth still relied upon a reading from that machine. The Commonwealth relied upon a reading from the officer of the screen, insufficient breath sample. What if the machine just was not working, which we don't know, right? In other words, so the question I think is that did you have to have a foundation about the machine and Officer Jenkins' qualifications with respect to the machine in order to put in anything, including, i.e., no breath sample?
So I think that reliability issue would be an issue for a motion in limine, and that was not raised.
No, you can raise by objection when somebody wants to put in scientific evidence. You can say, I object, Your Honor, and here are the reasons, including that it lacks foundation. And honestly, I read through what the opposing counsel said on this score, and it sure looked to me like he was raising that among a variety of objections to this evidence. It doesn't have to be an motion in limine. It can be right when it's being introduced, right?
Well, the reliability of a BT would typically be done in a motion in limine. I'm not aware of any case.
But there's no rule that says it has to be. Is
Well,
there?
The difficulty in this case, which is why I asked the first question I asked to your brother, is that everybody knew that no one was going to try to claim that these tests were reliable at this given point in time in the trial court, because they had been ruled inadmissible with respect to the readings. I don't believe the defense counsel would have known that no foundation would have been laid. I think defense counsel might have anticipated that some foundation would have been laid, either as to expertise or as to the machinery. And once it became apparent that nothing was going to be laid, I think that it is permissible to object at that point as well. But isn't the irony of this case that these tests had been ruled inadmissible because the machinery was considered unreliable, and that nonetheless the Commonwealth relied on the reading? In other words, I understand how this developed because all the usual rules were off. But if the machine had been deemed fundamentally unreliable, how could the Commonwealth rely on the reading?
I would say that the Commonwealth was not relying on the reading, and all of the issues with respect to the reliability of the BT at that time actually went to discovery issues with respect to OAT, and none of that is actually in the record here because none of that is raised. And I would say that under End in Soto, all that is required is for—
I'm sorry, counsel, we have to go by what is in the record. Mr. Panis literally said one of the concerns that the OAT had was that this particular type of machine was not giving readings. He made that argument directly to the judge. Here's what he said on pages 106 and 107, counsel. I don't think there's any evidence, there's any indication that there's even a keeper of the record, let alone someone that knows the machine, how it works, the inner workings of the machine. There's no indication this person has any basis of knowledge for that. If that's the case, I want to be able to go into the accuracy of the machine, because he's speaking to the fact that he could tell that there was an insufficient sample from what the machine registered, when in fact, that's not the question here. And then the court starts to say, well, he testified, he learns this from what the screen shows. And Mr. Panis says the following: but if the machine's not working properly, there's no way to determine that. This issue was squarely raised.
What, is there a question? I'm sorry.
Tell me why I'm wrong, because I'm struggling with this.
I'm not saying that you're wrong. I'm saying that—
You can tell him that he's wrong. It's okay. It's permissible.
Yeah, you can tell me that. I need to understand it. I'm looking at the language of the record and it's not consistent with what I'm hearing. That's why I'm raising this.
So basically, in order to put in a Curley and a Soto type situation in evidence, all that is required is the defendant's consent. Thus, the Commonwealth was allowed to admit this evidence. Then, on cross-examination and through the defendant's own testimony, she is able to rebut it in any way that she chooses. And what her rebuttal basically in her testimony was that she was not able to give a breath sample, which is consistent with what the officer saw. It's not like she's saying, oh no, I gave a breath sample and the machine didn't work. She's saying I couldn't breathe, and the jury did not accept that. And that is a situation that you find yourself in this fact pattern.
Unless the motion limine had not been allowed, and then none of it would have come in the first place, right? So,
of course, but that's an abuse of discretion standard, and I do not believe that the judge abused his discretion by allowing the Commonwealth to put in that she consented and then was not able to.
let me ask you a question, if I may. I agree with your interpretation of Curley and DeSoto. That is, once the defendant agrees to take the breath test and doesn't take it successfully, that's admissible. However, in neither one of those cases was it apparent that there was a foundation laid with respect to the accuracy of the machine, because in both of, and maybe there even was, but maybe it wasn't even an issue in that case. I wonder if you know, if you read something in those cases that might have given you an inkling that I didn't see. So in other words, one is the main point in those two cases is that, and as Justice Englander pointed out, there was observations of the defendant fooling around with the machine and not giving an appropriate sample. And as Justice Sullivan has pointed out, neither one of those cases, well, I'm going to piggyback on something she said, in neither one of those cases were we in this situation where no breath tests were being admitted because there was a problem with the machines. So how do we even know? As far as we know, that foundation was laid in those cases, but it really wasn't the issue. It is an issue here, square and center.
So we don't know in those cases whether there was a foundation laid. It certainly doesn't say in those cases that would be required. And I would point the court to an unpublished panel order, Commonwealth v. Lezen. And in that particular case, they say that the evidence was properly admitted. And this is a June 2017 case, so it's not too much before.
Is that attached to your brief? Yeah, I believe it is, right? Is that case attached to your brief? Okay.
Yes, it's in the addendum.
In neither one of those cases did they say that a foundation was required. Did the Commonwealth's position that if the testimony comes from reading the screen of a breathalyzer machine, that no foundation is required with respect to the machine itself?
Yes, and if I could just finish answering Justice Vuono's question, what was said in that Lezen case is that the defendant was unable to complete the breath test successfully, as he could only provide one complete test after multiple attempts rather than the two required. That is information that comes from the screen, that comes from the instrument. It's the same as this case. And I understand that's an unpublished order, but I think it is persuasive that a panel of this court has previously found that that was sufficient for an Andosoto Curley type admission of evidence. And I would suggest that it was here as well.
Surely the foundation rules can't be different with respect to whether the machine, so you have to lay a foundation if you want to put in the evidence of what the machine reads out, right? And then we've got cases on that.
No, I would disagree with that. I think you have to put in a foundation if you want to put in a breath test result under, I'm sorry, it's that case that begins with a Z, Zeninger, I think. And that foundation, yes, that foundation is set by proving 5 things, which is set out in section 24 and in the CMRs. And that includes putting in the statutory consent rights and consent form, which the defendant obviously thinks should not have been let in, and also the BT ticket, and there's one other, the periodic test result. And so had that foundation been set, which I would say you don't have to do here, because that you only have to do that foundation and set that foundation under the CMRs and under the statute when the breath test result is actually put in, which it was not here. But had that been done and had that foundation been set, that statutory rights and consent form would have come in anyways.
Let's leave aside the statutory right and consent form for a moment. I also agree that once there's consent, the evidence comes in. That's what Andon Soto says. But what we're dealing with here is not that preliminary issue. It's whether or not the evidence that came in was competent, because we're lacking the element of personal observation that was present in Curley. So when we talk about the results, we're talking about whether or not there was competent evidence of results. Is not you tried and failed 3 times as much of a result as you blew a 0.2 or a 0.5 or a 1.0? Isn't that a result?
No, I don't think so. It's an incomplete. It's a failure, as was said, and if you look at Lezen, you'll see that we have a similar situation to here. And I would say, no, you don't have to set that foundational requirement. And in any event, her testimony was also that she could not breathe into the instrument, that she was having a panic attack. It's all consistent. And if there are no other questions, I would rest on my brief.
All right, I see our time is up. I'll just check with the panel and I see no further questions. Thank you both very much. We'll take the case under advisement and we'll get back to you as soon as we can. Thank you very much.
Thank you for your time.
Thank you.
You're muted. There you go.
Yeah. Better safe than sorry.
Okay. Good morning. Let me begin by introducing the panel to you. With me today is Justice Mary Sullivan and Justice John Englander. I think I know you both. My name is Ariane, if you know. I just wanted to inform you that at the beginning of today's session, we paid tribute to Chief Justice Ralph Gantz, and we observed a moment of silence. Given our virtual platform, not everybody could participate in that, but his loss is certainly on our minds as we continue on with the rest of the day. I'm going to call the third case on our list for the record, 2019-1119, Commonwealth versus Ryan PASQUINI-PEZZINI, but I believe his name is now simply Ryan Pezzini, if I'm correct. And just a few preliminary comments. I want to thank the members of the Appeals Court for making our virtual sittings possible. If we have any technical difficulties, please be patient with us and we will be patient with you. And as a final reminder, the rules of appellate procedure apply to arguments in this platform, just as if we were in the courtroom. You each have 15 minutes. There is no rebuttal. We've read your briefs carefully and everything else you have submitted to us, and we're looking forward to your argument. Attorney Schnipper, please start.
Thank you, Justice Vuono, and let me just also add my sadness about the passing of Chief Justice Gantz, who is somebody I tremendously admired. Anyway, may it please the court, my name is Merritt Schnipper. I'm here on behalf of defendant Ryan Pezzini. As the court knows, this is a case involving the OUI manslaughter statute, chapter 265, section 13.5, and manslaughter requires proof of recklessness. Proof of recklessness requires the Commonwealth to show that a defendant knew or should have known of the risks created by his or her conduct. Voluntary intoxication is relevant any time the Commonwealth has the burden of proving such knowledge, and there are no exceptions under Massachusetts law to this rule. Voluntary intoxication is thus relevant in OUI manslaughter prosecutions, as it is in every case involving either recklessness or third-prong malice. Now, despite this very well-established law, the Commonwealth has asserted that in this particular case, the defendant's knowledge or lack thereof was not relevant to whether he was recklessness in the context of this case. The Commonwealth says that at page 44 of its brief, but that statement is at odds with the well-established law that I just referenced.
Counsel, let me make sure I understand one thing. You're not saying that there's any case under this particular, the vehicular manslaughter statute, that holds that alcohol intoxication is relevant, right? You're talking about manslaughter generally.
So this is not the vehicular manslaughter statute. That's chapter 90, section 24G, but the OUI manslaughter, sorry, the vehicular homicide statute, it's not a vehicular manslaughter statute.
Well,
So
I
there-
call this a vehicular manslaughter statute, which is probably the wrong term, but I mean the statute that we're talking about, which is OUI plus manslaughter.
That's right. There is no there's a statute specifically, there are multiple cases from this court saying that section 13.5, the OUI manslaughter statute, has the same mens rea as section 13, the ordinary manslaughter statute. Those cases include Commonwealth versus Guaman and Commonwealth versus Moore. Those are 2016 and 2017 cases. But those cases don't discuss the role of voluntary intoxication as it's well understood in the law of manslaughter more generally, in the context of this statute. However, I go through an extensive recitation in my brief of the way the rules of statutory construction apply and show that basically there is no showing that the legislature intended to displace the common law of manslaughter or abrogate it when it enacted this particularized manslaughter statute, and that the plain language of the statute gives no indication that the ordinary rules of proving manslaughter, proving recklessness, and just the relevance of voluntary intoxication don't apply here. Now, there was significant evidence of voluntary intoxication in this case. There was evidence the defendant was at 4 times the legal alcohol limit for driving. There was quite a lot of eyewitness testimony describing him as indicating behaviors, displaying behaviors indicative of extreme drunkenness. And of course, there was expert testimony explaining how his 4 times the legal limit blood alcohol content correlated with severely reduced ability to either perceive, take in, and make judgments about sensory stimuli that he was theoretically observing in real time. So in other words, to assess and respond to the risks that were created by his conduct. Is there a question?
Let me ask you about that. Yes, me. Am I coming through? I have a question about that. And that is this. So really what this case relies on for you is that the Commonwealth's case deteriorated after your expert was presented. Because up until that point, in fact, I think you concede in your brief that there was sufficient evidence of the crime, if I understand your brief correctly. Now, it's well settled that the trier of fact, here the judge, does not have to accept all the evidence that's presented by the defendant. In fact, may not be advisable, but to actually pick and choose and to cherry pick some of the evidence with respect to the expert's testimony is also permissible. So why couldn't, in this case, the judge determine, regardless of your argument about voluntary intoxication being relevant, and let's even say hypothetically, we totally agree with that position. That does not necessarily mean a new trial or a new trial, or rather the entry of guilt on the victim or homicide statute is warranted, because the judge could have found that your client either subjectively or objectively intended for his conduct and knew what he was doing as sufficiently enough that he drove his car, he was drunk, he was told, hit one car, was then told by that person, the victim, to get out of his car and didn't do so. So that's my problem with this case. Why? Help me out.
I will help you out. And let me just clarify that we have 2 arguments. You have correctly described in excellent detail our sufficiency of the evidence argument, which does focus on deterioration. We also have a separate argument that I'd like to step to later that talks about why the indications on this record are that the judge did not appropriately apply the legal standard as fact finder. In other words, did not appropriately instruct himself on the controlling law. But with regard to the deterioration argument that we have, the argument is this. I mean, deterioration occurs, this is Commonwealth versus Mary, Commonwealth versus Cater. Deterioration occurs when an element necessary for the Commonwealth to submit the case to the jury, or in this case to the judge, is shown to be either conclusively incorrect or to be simply incredible after the defense case. Now, in this case, we're not talking about one person who says in the Commonwealth's case, I saw the defendant shoot the victim, and somebody else says, I saw somebody else shoot them during the defense case. We have expert testimony here that's based on human physiology and the effects of alcohol in the central nervous system, and thus carrying on into the effects on the person's perceptive and judgment apparatus. That testimony was largely undisputed at trial, and what it showed was that the defendant was well on his way down the ladder of central nervous system depression to sleep, that he had lost the ability, and that any other similarly situated person would, at 0.3% blood alcohol, would be unable to take in, respond to, and make judgments about events as they are evolving in real time. Now, it's certainly quite possible that a fact finder might hear that evidence and remain skeptical about whether or not that's the case. But of course, the question in the sufficiency analysis is not whether there's any evidence to support the opposite view. It's whether a rational fact finder could find it beyond a reasonable doubt that in this case, Mr. Pezzini was capable of and actually did perceive what was going on around him and make a judgment about the decision to run that risk. So based on,
yes. The question that I have about that particular argument is that is the prior accident in which he's stopped, he's asked to pull over, and he has the wherewithal as soon as the other driver turns and starts to walk away to peel out and flee the scene. Doesn't that indicate enough capacity for rational thought to permit a judge to reject the expert's testimony?
Well, I certainly think that given the strength of the expert testimony, it needed to be rejected if it was going to be rejected with some sort of reasoning. But Dr. Powers, the expert witness, I think explains in significant detail that there's a difference between what he characterized as automatic responses, like, this is in my way, move it out, I'm continuing. In other words, part of the act of driving, which itself becomes basically automatic, is basically operating in the lizard brain level, and the level at which people are assessing and making judgments about risks based on evolving stimuli. So that's the difference.
But he pulls over in response to a request to pull over, which is, I would hope, past lizard brain. And then as soon as she's out of the way, he takes off. So there could have been an acquittal here based on your theory, but that's not how we look at it. We look at it in the light most favorable to the Commonwealth. Couldn't you give that chain of events that characterization? That was a very wily move?
I think that qualifies as the scintilla of evidence that's referred to in many a sufficiency case. But I think given the weight of the expert testimony, I don't think that a fact finder could be beyond a reasonable doubt on that question. I think that's the essence of the sufficiency standard, is that yes, there is some evidence, even after the expert, to support the idea that he knew what was going on around him. The question is, was it proved beyond a reasonable doubt? But moving more generally to the judge's treatment of the role that voluntary intoxication plays in these prosecutions more generally, not a sufficiency question, but just simply whether it needs to be considered at all. I think the judge's comments from the bench and even more particularly his comments in his written denial of the motion for required finding show that he did not understand, did not properly apply the law of voluntary intoxication in the manslaughter context in this case. He specifically talks about there being sufficient evidence to prove both the objective and the subjective prongs of the intent requirements. The intent requirement in a manslaughter case is a general intent to perform the act that results in death. It's a very different question, as the Supreme Judicial Court has talked about in Commonwealth versus Sama, to the knowledge requirement, which includes both a subjective and objective component. Both, was the actual defendant able and did he or she cognize the risks created by his or her conduct, and were the ordinary person in the same circumstances? And the same circumstances in this context means a person under the same level of intoxication as the actual defendant.
Counsel, I need to interrupt for a second to make sure I understand your argument. The judge in his written statement says, while intoxication may be taken into consideration in determining recklessness. So in his written document, he suggests that intoxication is relevant. Is your argument that the judge's error of law was he believed that intoxication was not relevant at all? And if that's not what he did wrong, then help me understand what he did do wrong.
What he did wrong was that he correctly assessed. Now, there's lots of different intoxication considerations, and being intoxicated can be an indication of recklessness, right? Being intoxicated in a situation where not being intoxicated is called for because the things you're doing pose risks of harms to others can be a consideration of recklessness. But what we're talking about here is the extremely well-established requirement that when a person is held liable for a manslaughter or other reckless charge based on the notion that they knew of the risks they were creating with their conduct but disregarded with them, voluntary intoxication is specifically relevant to the idea of whether they were able to cognize those risks. And the reason we know that the judge—
how do we know he didn't? How do we know that he got that wrong, right? We have the basic law, which is he's presumed to have instructed himself correctly on the law. I mean, the rest of that sentence that I just read to you actually says, while intoxication may be taken into consideration in determining recklessness, it is certainly not a bar to a finding of recklessness. So he was in that sentence, at least, on exactly the issue it seems to me that you're concerned about. How do we know that he got the law wrong?
Because he goes directly to this statement about intoxication not being a bar to criminal liability, which is exactly the rule of law that Commonwealth versus Sama distinguishes when it affirmatively states that in every case where there's evidence of voluntary intoxication and there's a recklessness charge, the voluntary intoxication must be considered when the fact finder is determining whether the person was capable and actually did disregard the
Because
risk.
it's not a bar, I believe, orally at the close of all the evidence, right? So there are two places where he addresses this. One is in the written document, which I think is his response to the motion for directed verdict. That's what I was just reading to you from. Then at the close of all the evidence, he does make this statement, intoxication is not a defense. When he makes that statement, I believe that's oral. And he also refers back to what he's already said in that same statement. Am I missing something?
I don't think you're missing something. I think you're not taking in the record for the fullness of the unwillingness to address the implications of the defense argument that the judge manifested during this trial. The judge plainly reacted strongly against the idea that in a drunk driving related offense, voluntary intoxication could be an impediment to finding the necessary mens rea. But that is simply exactly what this statute requires. And the judge, because defense counsel was making clear and was making clear throughout that he was far from arguing exculpation based on intoxication, he was affirmatively stating that the defendant, and we are stating here, that the defendant could properly be convicted under section 24G of chapter 90 of negligent vehicular homicide because his conduct plainly deviated from the standard of care. But
what case would you rely on? What would be your best case for us, for avoiding the general presumption that the judge instructed himself correctly on the law based on these statements that were made that we just talked about?
I would urge the court, the court, to my knowledge, has never found that a judge incorrectly instructed themselves in the law, but the record here simply cries out for that conclusion because the judge is plainly just going right past the idea that Dr. Power's testimony needs to be considered in the context of recklessness, and instead is simply saying that, no, I'm not going to accept that your client's voluntary intoxication is a bar to criminal liability. And again, that shows on a very plain record that he was misconstruing the core of the defense argument. In fact, the only contested issue at trial.
Panel Chief, may I have one question?
Please go ahead.
Very quickly, counsel. Do you say that the reasonableness standard is taking
Just
into
one moment,
account?
there's a bit of a freeze.
I'm sorry?
Taking into account the
I'm going to ask
level
our
of
clerk to come up. It appears that
you're frozen. Yep.
I can hear you, Justice Sullivan.
Okay, taking into account the level of intoxication of the defendant as the fact finder finds it, is the reasonable person who evaluates that the reasonable sober person or the reasonable person at the same level of intoxication?
It's the reasonable or ordinary person at the same level of intoxication. I would say that conclusion as a matter of law is required by the SJC's decision in Commonwealth versus Mountry, which is 463 Mass 80 from 2000.
Yes, I reread that this morning and it simply says reasonable. Oh, we're going to stop.
All right, thank you.
Well, we're going to wait for our panel chief to come back.
Okay.
oh, are we back on?
Yeah.
Yeah.
We're waiting for you.
Oh, thank you. I guess I was the only one frozen out. I apologize. Justice Sullivan, I didn't hear your actual question when you started to pose it.
I'm very sorry. I thought you could hear me. I asked whether the reasonable person standard was the reasonable sober person or the reasonable intoxicated person, and counsel's answer is under Mountry, the reasonable intoxicated person.
Thank you. I apologize for that. I was frozen out. Now we have the answer. Any further questions to follow up on Justice Sullivan's comment? No? All right. Okay, thank you both for that. Thank you, Attorney Shipper, very much. And we'll now turn to Attorney Wendell.
Good morning. May it please the court, ADA John Wendell for the Commonwealth. If I may, I'd like to start with Mountry, actually. Attorney Schnipper accused me of ignoring it in my brief, so I'd like to address it briefly. I embrace the holding of Mountry. Mountry is absolutely correct law, but the reasonable person under Mountry is the reasonable unintoxicated person. I would suggest Mountry is very clear on that. The, if I may, the improper instruction in Mountry, this is at page 89. The judge was saying something about you may find that the defendant should have known if the average reasonable person not intoxicated and observing the situation as it existed would have known that the victim in that case did not consent. That's incorrect law. The correct law is the average reasonable person not intoxicated, but knowing what the defendant knows in his intoxicated state. There's a difference between what we might call subjective knowledge and what we might call objective comprehension, objective understanding. In Mountry, this is page 91, the subjective component focuses on the defendant's capacity to possess the requisite knowledge for which his state of intoxication has relevance. The objective component focuses on what the average prudent person possessing the defendant's knowledge would have understood. This is entirely consistent with my quotation in my brief from Wolanski. This is at page 398 in Wolanski. Knowing facts that would cause a reasonable man to know the danger is equivalent to knowing the danger. The reasonable person is not intoxicated. When we assess objective recklessness, we begin with the subjective component. What does the defendant know, or what could he reasonably be expected to know based upon his level of intoxication? Taking that knowledge, we then move to the objective component. Knowing that, would the reasonable person take the actions that he took, or would they understand not to take them due to some existing risk of serious harm or death to some other person? This is entirely consistent with the model instructions. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by his conduct, his subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of danger. Even if the defendant himself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. The reasonable person is not intoxicated. The defendant's intoxication is not relevant to what the reasonable person knows. The defendant's intoxication is relevant to the facts from which the reasonable person makes their assessment of risk. So when I argued in my brief that voluntary intoxication is not relevant to OUI manslaughter, that's not because OUI manslaughter in any way fails to adopt the law of both common law manslaughter and OUI. It's merely a quirk of the facts. There are...
But if subjectively, just hypothetically, if subjectively the defendant was so intoxicated that he was in the state, as Attorney Schnipper has put it, of lizard brain, then on your theory, does the objective, the reasonably prudent person look at that and say, he was completely incapable of doing anything other than autonomic responses, and the driving was automatic, and therefore acquit?
No. That actually, that goes to a secondary point of confusion in the defendant's brief. The defendant confuses knowledge and intent. As far as the knowledge component of recklessness goes, the reasonable person, understanding that the defendant is at the point where he is beyond perception. If the defendant is beyond perception, he's functionally blind and deaf. for all practical purposes. He knows as much about his surroundings as a blind and deaf person would know. The reasonable blind and deaf person is not going to be driving a car on a public way at this time of night in the presence of other traffic. They're not going to be doing that because that is ridiculously dangerous.
Well, the problem with that argument is that in Mountry, the SJC permits the possibility that somebody can be so drunk that they don't know that someone else hasn't consented. I don't know if you can take Mountry and say that if you get that drunk, you wouldn't ever get in the car. Because they do posit it as a defense in Mountry.
It's a defense, but again, that goes to the question, and before I continue, I know my time has expired, but I thought I had several minutes left.
I think that may be incorrect. So I'll ask the clerk to check on that. I will contact him via email. Keep going.
Thank you. It goes that Justice Sullivan, I believe, goes to the difference for recklessness purposes between knowledge and intent. If the defendant is so drunk that he lacks the capacity to know his surroundings, then he is functionally blind and deaf. The reasonable person being functionally blind and deaf will not drive in these circumstances because of the extraordinarily serious risk inherent in doing so. If the defendant is too drunk to intend to drive in those circumstances, then we have a potential problem. The defense here, which this goes to what the motion, what the trial judge said. The trial judge focused primarily on intent in his argument on sufficiency. He's correct to do so because if the defendant is incapable of intending to drive due to his intoxication, then his act is not reckless, owing to the fact that a reckless act must be an intentional act. If he knows nothing but still intends to drive, the reasonable person, not being aware of their circumstances, would know that that creates a serious risk of harm and would not drive. So he knows facts which the reasonable person would understand to create a serious risk. He undertakes an intentional act. If he does not intend the act, he is not reckless because recklessness requires intent. If he does not have the intent, then he is merely negligent.
Am I right that the logical extension of the argument you're playing out is that as a matter of law, the defendant could not put on evidence that they were too intoxicated for this particular statute?
No, not quite, Your Honor. That was actually a concern of the trial judges. He can put on evidence that he's too intoxicated because he is too intoxicated to have the necessary intent. What he put on was, I was too intoxicated to have the necessary knowledge. But there's no point at which what he knows creates circumstances in which the reasonable person would not foresee a serious risk of serious harm to another individual based upon his driving. There are circumstances in which he may not intend. So if there were some evidence that—
Stop you for a second. It's extremely esoteric, at least for this particular person, to try to wrap my head around. And it seems to me to be something that I would prefer to have had an expert say. There was no expert testimony from the Commonwealth in this case, right?
Correct.
Your position is he can't, under the law, he can't be too intoxicated to have knowledge, but he could be too intoxicated to intend?
Essentially, Your Honor.
As I understand the manslaughter law, and I may not have it quite right, knowledge basically falls out of the definition of intent, doesn't it? I mean, knowledge is one prong. Well, knowledge is either subjective or objective and goes to the what a person would have understood about the circumstances they were creating by their conduct.
That, I'm not sure I understand.
Intent gets taken care of early by simply saying all you had to do is intend your act. You didn't have to intend the consequences of the act, right? That's one sort of way that they look at intent with manslaughter. But then they go back and they say, but you have to, your behavior must have created consequences that you knew created I can't remember the exact language, but a very, very significant risk of harm. And that's where we start talking about knowledge, right?
Not, well, yes, Your Honor, but I must disagree with your characterization of the law. It's not you must have intended this conduct that you knew created this serious risk. It's you must have intended this conduct that, based upon the facts which you knew, the reasonable person would have known created such a risk. So in the judge's instruction in Wolanski, page 398 to 99, that the Supreme Judicial Court said was correct is, even if a particular defendant is so stupid or so heedless that in fact he did not realize the grave danger, he cannot escape the imputation of wanton or reckless conduct in his dangerous act or omission if an ordinary normal man under the same circumstances would have realized the gravity of the danger.
Yeah, I saw that and I wondered if you could square it with Moundry.
Yes, Your Honor. The ordinary normal man under the same circumstances is the reasonable person. They are not intoxicated. They do not share the defendant's state of mind. That must be so because otherwise that instruction is nonsense. If the ordinary normal person is of the same state of mind as the defendant, then the ordinary normal person is so stupid or heedless that they do not realize the grave danger. This instruction that is given is consistent in the Supreme Judicial Court's view with their own statement that knowing facts which would cause a reasonable man to know the danger is equivalent to knowing the danger. So
The concern I have about your argument is that there's a certain heads I win, tails you lose quality to it that I find difficult to square with Moundry saying that this defense has to be available. Can you help me out here?
Well, two problems. Number one, the defense, the mens rea in Moundry was a knowledge mens rea. The defendant had to know that the victim did not consent and knowingly engage in this conduct. That's a different mens rea than the recklessness mens rea, which is the defendant must know facts from which a reasonable person would understand a danger to exist and must act in disregard to that apparent danger. So we're fundamentally dealing with
that the general cases are about the defendant's state of mind. Moundry is not about the defendant's state of mind, really. It's about his knowledge of the victim's state of mind.
But his knowledge of the
victim. It doesn't go to recklessness, it goes to her consent.
Not quite, Your Honor. In Moundry, both states of mind are relevant. It's his intoxication impairs his ability to understand the effects of her intoxication. So what he knows is whether or not she consents. His knowledge is based upon certain facts, which are what he knows will be dependent upon his own intoxication. If, based upon what someone as intoxicated as himself knows, the average person would know that the victim is too impaired to consent, then he's guilty. If not, then he's not. I see my time has now expired.
We reset your time, and I think we were slightly generous. We hope we were correct in trying to evaluate it. But in any event, I want to be sure that the panel has had enough time to ask you all the questions that they want to ask. So
I apologize to both of you, but I do have one more.
Sure.
What do you say to Counsel Schnipper's argument that the judge appears to have thought that he could not consider intoxication with respect to this statute as an appropriate defense?
Two things. First of all, I would call back to your Honor's earlier discussion of what the trial judge actually said that would suggest he did understand it. Second, as I've argued, the primary issue in a case of this type is actually going to be the defendant's intent, not the knowledge. Thus, the trial judge properly focused upon the defendant's intent as the dispositive factor in the particular circumstances. His assertion that intoxication is not a bar to liability is an accurate statement of law. So it's our position that he correctly instructed himself and that his focus on intent emphasizes that correct instruction.
Anything else? Justice Sullivan, any further questions? No. All right, Attorney Wendell, I'm sorry for the fact that your argument was interrupted once or twice with some difficulties, but we had your brief. Okay, and is there anything else you want to say to us before we move on to the next case?
No, thank you. If there are no further questions, I'd rest on my brief.
Okay, fine. Thank you very much. Thank you both very much. Please be careful, stay healthy and safe during these troubling times, and we'll get back to you with an answer regarding your issues as soon as we can. Thank you. Okay. My screen indicates that we're live, so I'll say good morning and begin by introducing the panel. Joining me today is Justice Mary Sullivan and Justice John Englander. I think I know you both. My name is Ariane Vuono. I want to inform you that at the beginning of today's session, we did pay tribute to Chief Justice Ralph Gantz, and we observed a moment of silence. Given our virtual platform, we could not include everybody in that, and so, of course, you're not able to participate, but I wanted to let you know that we did do that, and his loss is certainly on our minds as we continue on today. I'm going to call the fourth case on our list officially. It's 2019-1358 in the matter of the estate of Carl Manning Widdiss. A few preliminary comments. I want to thank the appeals court for arranging these virtual sittings. During the course of your argument, we may experience a problem or two, a technical glitch or so. If so, please be patient with us. And if you have any problems, we'll be patient with you as well. The usual rules of appellate procedure apply. You each have 15 minutes. There's no rebuttal. And we've read your everything you've submitted to us carefully. And we look forward to hearing your arguments. So I think Attorney Vuono, you're the appellant, if I'm not mistaken, correct? You may begin.
Good morning. Good morning, members of the panel. May it please the court. My name is Marilyn Vuono, and I represent Pamela Glavin in this appeal from the dismissal of a general equity complaint that was filed in the Dukes County Probate Court a couple of years ago, seeking three forms of relief in the alternative. One was a distribution of the real property subject to a life estate. Number two was an amendment of the intestate order in order to reflect the existence of the decedent's spouse. And the third was a request to vacate the intestate order in order to file the holographic will that the decedent had drafted and signed in Arizona about 6 weeks prior to his death. This complaint and all three counts were dismissed without any evidence and testimony on the merits, and in particular of the life estate, which is a mixed issue of fact and law, and without any explanation as to why the principles of equity and fairness precluded Ms. Glavin from a remedy in this case. As you know, the probate courts have historically been tribunals where equitable principles applied and where someone could seek a remedy. That's what the courts are for. And the lower court did not explain why these equitable principles don't apply in this deeply unfair and unjust result that Ms. Glavin is now having to deal with. We requested expressly in a motion for reconsideration with the judge to consider and explain why these principles of equity and fairness do not apply in this situation, and the request was ignored, I guess. The entire complaint, for the most part, was dismissed based on speculation about the validity of the decedent's wishes and his...
Well, the complaint was dismissed on the basis of the statute of limitations, which is always a harsh result. I mean, we first have to determine whether or not we are even able to address the equities. And I'm struggling to understand how it is that the ruling, the specific ruling on the statute of limitations was incorrect. Tell us why, under the law as it applied to that specific provision of the statute, was something other than what the judge said it was.
So respectfully, I disagree with the procedure for determining whether this case can go forward. I think historically, it's not that the court needs to determine whether the statute of limitations applies before the equities are considered. I think the equities are infused into the statute of limitations, just like they are in every other facet of the probate laws. And in fact, the Uniform Probate Code at 1-102 even states that the chapter shall be liberally construed and applied to promote its underlying purpose and policies. One of those purposes and policies is to, quote, discover and make effective the intent of the decedent and distribution of the decedent's property.
Do you have any case that says that we can avoid the language of the statute of limitations? It's a statute, 190B3-412, because the equities don't allow us to, as opposed to, for example, equitable tolling or some other reason?
Well, I would submit that there was a form of equitable tolling here, but before I get to that, let me answer your question. I believe that the statute itself allows for equitable consideration of the facts. I think subsection 4 of that statute provides, just much like the savings clause in Rule 60 for relief from judgment, and a savings clause, if you will, to consider something more than just the timing. And moreover, if you— your brother says the way to read section 3-412 is that the section you rely on is referring back to subsections 1 and 2, which are both subject to a 12-month limitations period. I don't recall there being a case associated with his argument, but I do have to concede that I thought his argument structurally made sense, because otherwise you have the problem that 1, 2, and 3 don't make any difference if you decide that you think that it's appropriate under the circumstances to ignore them. What do you say to that argument? I would say that there should always be an opportunity for the probate court to consider something other than a bright line rule. I mean, are we really to believe that the legislature intended the UPC to affect an inflexible rule about how long a testator's testamentary intent even matters, or how long it matters?
We could, because at a certain point you have to have finality in order to distribute under a will. Now, another possible approach to this is that, as I understand it, at the time that this appeal was taken, the inventory was not complete. So in that sense, is the appeal premature?
Well, it isn't premature because the parties being my client as well as the decedent's brother and sister, who are the respondents here, had all agreed to carry out the terms and provisions of the last wishes of Carl Widdiss. And at that time, they were all proceeding forward for several years. And this is where the tolling issue comes in. Ms. Glavin had no reason to believe that there was there should be any concern that Carl's wishes would be carried out. They were members of the Wampanoag tribe. They practiced the practices and laws and lived by the Wampanoag culture. And
that is that equitable tolling requires some kind of representation that caused her not to act. And you have her own representations when she filed that are now contrary to the positions she's taking, right? She represented there was no will. She represented that there was no spouse.
Right. But those, again, were, so those were based on her good faith reliance on counsel's advice. Her counsel at the time advised her that the will wasn't valid and that the will would not be enforced in Massachusetts, when in fact, the will.
Who was that counsel? Is it the one who submitted the affidavit?
Yes, correct. And he admits to the same thing in his
That gives you
affidavit.
That gives you a malpractice. I understand how that might arguably give her a malpractice claim if you believe that that advice was defective. But how does that provide a basis for essentially a do-over in the probate court? Have you got any case law that suggests that where there's been legal malpractice by the first lawyer who probated an estate, that you can then reprobate that estate? I may not be using the correct terminology, but I think you know what I mean.
I do. And there is case law that, in fact, I don't believe I cited in my brief, that whereby there's been malpractice by an attorney in the probate court that prevented a remedy, and you know, consistent with the spirit of the probate court, oftentimes with tolling, as Justice Englander pointed out, it really requires more. But it's interesting to look at some of these cases in the probate courts where equitable principles do apply, and the courts do apply them. So in the case of the estate of Grabowski, which is 444 Mass 715, in that case, the attorney's mistake, which was, I believe, filing an action late against an estate in order to proceed on a creditor's claim, was told. And I believe that also involved a child that had been exposed to some lead. And also in the case of Level versus Level, which I believe I do cite in my brief, in that case, the court first looked at whether the person requesting the relief had a meritorious defense. And in this case, we have the objective good faith reliance on counsel. And you're right, that was the triggering point for Ms. Glavin to file the probate petition. But it was the agreement among the parties, which was, again, objectively reasonable because it was consistent with the Wampanoag traditions, where your word is your bond and the parties can reach oral agreements. There's affidavits by Chief Melanson, who is the chief of the Wampanoag tribe, in my brief, who explains that these two people were indeed spouses, and that in the Wampanoag traditions, you can make a will orally. So
I was confused by the references to Native American law, because in general, in my experience, which is limited, that law goes with geography. And what I mean by that is it obtains on a reservation. And I didn't see any reference to whether this property was on a reservation, or what is the reason why we would think that Wampanoag law applies here?
Well, I'm not asking that the court apply the Wampanoag law, but what I'm suggesting is that, putting this in context for Ms. Glavin, there was a written will that she was told was not effective and valid in the white man's world. And that was something that she was readily capable of accepting, given her context at the time. And as far as the spouse is concerned, she didn't believe that her spousal union would be recognized by the Commonwealth. And you know, I think that she have made some mistakes indeed, but I'm not really convinced that the law shouldn't suppose the fortitude necessary to belie counsel when you're grieving over your spouse of 35 years. And, you know, notwithstanding any timing concerns, time doesn't erase the testator's intent. Time doesn't erase a spouse. And I understand that there's a statute of limitations for challenging some of these issues, but even if that's true, there's still the issue of the life estate. There is a life estate. There was a writing granting a life estate. Now, whether that grant of a life estate is testamentary, whether it's a non-probate conveyance.
Let's assume, because there are actually a couple more things to talk about. We seem to have a lot of complicated cases today.
Yeah.
Let's assume for a moment that it's testamentary. I understand you have an argument that it's inter vivos. What is your evidence of an agreement?
Between the Miss Glavin and
Yes.
yes. So there are emails where they acknowledge these conversations, but in addition to that, there's the affidavit of Tom Murphy, who was representing Pamela Glavin at the time. And in that affidavit, he states that Donald Widdiss had agreed to the life estate. And that is also true with Pam Glavin's affidavit, where Don Widdiss agreed to the life estate. And once again, putting this in context, so
you suggest in your brief that one way to look at this, and of course this is, I think it's a motion to dismiss a complaint, but we're going to have to talk about that for a moment later. But it's on motion to dismiss. You suggest that there is a lease that's generated here. Does it have to be in writing under the statute of frauds? And if so, why not?
Well, it doesn't have to be in writing under the statute of frauds when there's reliance and performance. And in this case, Ms. Glavin relied on the ratification, if you will, of the will, and the parties were all carrying this out, this will and the terms and provisions of the will. If you look at the will, the decedent wanted Ms. Glavin and Heath Widdiss to serve as the personal representatives, and so they did. He wanted Ms. Glavin to have a life estate, and they were carrying that out for over 3 years. He wanted his life insurance policy to be used to pay off his mortgages, and that's exactly what was done.
Is indulging me by not telling you that your time is up. But if I could, Judge Vuono, I have one more question.
Please go ahead. Go ahead.
I apologize. Counsel, I just need to, I don't understand the nuances of the jurisdictional argument that was made by your opponent, but he suggests that, and I think it's along these lines, because the original intestacy is still open, the filing under a different number is not the way this should have been done, that it should have been filed, I guess, in the previously existing case, not yet closed. What do you say to that?
Well, to be honest with you, I had called the probate court to discuss this with them before it was filed, and it was suggested to me that a general equity complaint be filed because it can address all the issues. I recognize the problem, but it certainly, there was no strategic element involved in that. It was just merely
suggesting that, at least with this judge, she doesn't even understand it yet, but okay. Thank you. We could leave it there.
Okay, well, your time is expired, and unless Justice Sullivan has a question she wants to follow up on, you can rest on your brief on the rest of your arguments. Okay.
Thank you.
All right, Attorney Coham.
Good morning. May it please the court, Dana Curhan for the two defendants here. The question in this case is whether the judge erred as a matter of law or otherwise abused his discretion in dismissing Glavin's complaint. And our contention is that he did not. Before reaching the merits, this case is a procedural mess. As Justice Englander just indicated, the original probate case was still open. And I think there was no reason.
Open. Why? Because there was an order that that apparently is so significant that it starts a statute of limitations running. So you know, there was a reference earlier to sort of you know, heads I win, tails you lose. You say, well, that order that was entered back in 2015, 4 years before, was sufficient to start the statute of limitations for 3.412, but in fact, the entire case is still open. Help me with that.
Well, I mean, I think where the case is still open, I mean, where the case is still pending and the property hasn't been distributed, there's still an active case. Why are we filing something under a different case number? Why aren't we going back to the original case and setting that aside? Now, the statute, there's
raised at any time before you raised it in your brief?
I'm sorry?
Was it raised at any time below?
I don't think it was. I recognize that as a potential issue. And I'm not sure. I have mixed feelings about it, because if it's interlocutory, then we may have to go do this appeal again, which I don't particularly want to do.
That's my question, which is, if you're right, if there's no final judgment in that other case, and nobody has even begun to talk about Rule 15 or Rule 60, and I haven't looked at them in the probate context, but if you're right and there's no final judgment in that case, are we even properly here, and should it not be decided in the original case?
Possibly. I mean, quite possibly. And I didn't address that in my argument section. I addressed that in the statement of the case in a footnote, and I did fully explain it. But I think that's problematic.
And I appreciate the fact that you raised it in your brief.
Yeah, and I think, you know, assuming she gets past this problem, you know, that we have a timeliness issue. Now, 3.412 actually, sections A and B don't contain a statute of limitations, and that is if you discover a will that you didn't know about, or if you discover an heir that you didn't know about. There's no statute of limitations on that as long as the case is still open. That's not the case here. Section 3 is the one, is 3 or C is the one that creates the statute of limitations if there's no new will, no new heirs. And I think that's where we're operating. And I think it's fatal to Glavin's claim.
Why is it fatal to her claim that there was an agreement to allow her client to remain in the property? Why is it fatal to that claim, which is based in contract?
I think I'm not sure where the agreement is. I mean, I don't see an agreement in that purported will between the decedent and Glavin. I also,
well, doesn't she, I mean, I read the complaint. It seems to allege an agreement. And aren't we on motion to dismiss?
Well, I mean, we are on motion to dismiss. The problem is that, you know, this is something that should have been addressed in the original case as maybe a claim against the estate, saying, yeah, I have a life estate, but not in a new complaint filed 4 years later.
Well, but she's saying, suppose she says it's not. You don't think that she could raise, she meaning the plaintiff, could raise separately from a claim against the estate an allegation that by contract arising after death, the heirs agreed that she would have a tenancy for life?
Well, the problem in this case is that the heirs didn't agree that she should have a
Well,
tenancy.
but now that, I think, if she's alleged it, that's a motion to dismiss. I mean, you know, you can defend that, but suppose it's alleged.
Well, if it's alleged, I mean, it should have been raised in the original. There are mechanisms in the original case for raising that issue, and they were not raised. And that's really what the problem is here.
Is there a final judgment in the original case?
There's no final judgment in the original case because the case is still open.
That's what I'm just, the probate court can be particularly confusing because yes, the case is open, but we see, maybe I should phrase the question differently. Is there an appealable order in the original case to which this appeal relates?
Not in the original order. I think that has to wait until the whole case is resolved. Now, so it's still interlocutory. Now, as far as there is an order dismissing a new complaint in equity, and that is before this court, but that is not, I don't think that's a particularly difficult case to address because number one, we have a statute of limitations. And number two, I think Ms. Glavin has a huge waiver issue in that she went into the probate and family court and said he died intestate and without a spouse, without a surviving spouse.
But that, again, neither one of those, none of the issues that have to do with Arizona, with the will, the appropriateness of the will, none of it, it seems to me, prevent an argument that says your clients agreed post-death that she had a lease for her lifetime. That's based in contract.
That may be based in contract, but I mean, I don't know why that is being raised in a new complaint. And by the way, the new complaint asked to sort of reopen and redo the original, that original order from the first case, from the case that's still open. That's really what it's asking for. Why are we?
Well, she asks, it's so, yeah, I'm struggling with this, and any help you can give would be greatly appreciated. Well, the title of it is general petition. This is a petition, the first 8 words, to distribute the real estate of Carl Manning Widdiss. Now, if she says, I want to distribute that real estate now, I'm ready to do it. I guess she's appointed administratrix, I think, right?
In the original case.
I want to distribute it, and I'm retaining a life estate for myself because, she says, I have a lease for life. Isn't that something that's appropriately within the scope of her petition? And if not, why not?
If not, and because it's within the scope of her duties in the original case, which is still open. But as far as filing a new complaint saying we have some additional claims here, or we want to distribute the real estate in some manner, the problem is that you have 2 open cases. If we allow this to go forward, you have 2 open cases and the potential for inconsistent results. And, you know, a lot of what she's asking for, not all, but a lot of, probably most of what she's asking for is a redo of the original petition that she filed 4 years earlier.
What would be the doctrine? So it is not uncommon in our law to have 2 cases pending in the same court on the same subject matter. It happens. And it certainly happens to have 2 cases pending in 2 different courts on the same subject matter. That's what res judicata law is all about. What is the doctrine that would prevent her from initiating a separate case that has to do with, or that seeks relief that bears on an open case in the probate court? Do you follow what I'm saying?
Yeah, I think if the subject matter is the same, in this case, the existence of a life estate, the existence of a purported will, whether she's a spouse, and I think I'm going beyond your question, but I think
No, you're not really. Thank you.
if all of that, that's all exactly the subject matter of the first case. So
But why weren't they consolidated?
Just thinking about along those same lines, why couldn't they have been consolidated?
They probably could have, but I think where the main, I guess the main relief that Ms. Glavin was seeking was sort of a change in a fundamental change in the initial complaint or the initial action, which is this is a state where he had a spouse and he had a will, and we want this will recognized. So it probably could have been consolidated, and then you'd have the same result. It would be dismissed because, you know, it's beyond the statute of limitations. No new spouse, no new heirs. The will was known at the time it was filed.
Allegation that she's got a tenancy for life that isn't subject to that statute of limitations.
Well, I think that the estate for life is contained within the purported will. If the purported will is not valid, then she doesn't have an estate for life. And
Well, this relates to I'm sorry, Judge Vuono, did you have a question?
No, go ahead. Go ahead.
This relates to an earlier question. Let's say hypothetically, instead of filing a separate action, this had been filed in the probate court under some procedural mechanism, be it a motion to amend the original complaint or a motion to vacate the original order or both. Would the statute of limitations have applied at all?
yes,
In that circumstance? And
Yes.
what in the language I guess it would be subsection 2 governing intestacy, would say that the statute began to run on an interlocutory order?
I think the language of the statute of 3-4.12 that has, you know, that has a limitation period, and it does not talk about, you know, when the judgment becomes final or anything like that. It talks about the filing of the petition. All right, I think that's the way I read it. So if it starts running at the filing of the petition, that's when, you know, we want something to be final. And, you know, obviously heirs and wills and things like that, those will probably show up within the year. But if they don't, or if there's some other reason, you get a year to go back and amend and file something different. Now, she waited until there were a lot of external circumstances, in particular that she was getting evicted from the house, and then came back 4 years later and said, on the eve of trial in the housing court on the summary process, said, hey, by the way, I was the spouse and there's a valid will.
Can you just walk me through the language of 1 or 2? Because 3.1 says there's a personal representative has been appointed the time of entry of the order approving the final distribution, which I gather we don't have, or if the estate is closed. So you're saying that it's a year from the appointment of the personal representative, period?
I think that is, or the filing of the petition.
Okay.
The filing of the
Judge
intestacy.
Sullivan, if you look at 3 talks about prior to the earlier of those 3 time
No,
limits.
I understand that. I just want to make sure I understand the argument.
Okay. We also, you know, I don't concede any of the merits. I think that, you know, Arizona allows holographic wills, but there are issues with that. And there are also issues with the recognition of tribal marriage, but those are in my brief, and I'll leave them to the brief.
Any further questions from the panel? Seeing none, I'll thank you both very much for your arguments today. Just on behalf of the panel, I want to say to you both that we hope that you and your families remain safe and healthy during these troubling times. We'll take your name is Ariane, you know. I just wanted to inform you that at the beginning of today's session, we paid tribute to Chief Justice Ralph Gants, and we observed a moment of silence. Given our virtual platform, we could not include everybody with that, and of course, I apologize that you could not participate, but his loss is certainly on our minds as we continue our work today. I'm going to call the fourth case on our list, 2019-07115, John Doe number 356197 versus the Sex Offender Registry Board. Just a couple of preliminary comments before we begin. And that is, during the course of this afternoon, we may experience one or more technical difficulty. And if we do, we ask for your patience. And just a brief reminder that the rules of appellate procedure that apply, as if we were in the courtroom, apply here as well. So you each have 15 minutes to make your argument, and there is no rebuttal. You can be confident that we've read everything that you had submitted to us, and we look forward to your argument. So I believe the appellant is Attorney Tennant, am I correct?
Yes, Your Honor.
Please begin.
Thank you, Your Honor. May it please the court, Eric Tennant on behalf of John Doe. I want to start actually with the last issue on internet dissemination, because I think hopefully I can make it a little easier on the panel. When I first litigated this case, it was before the Doe 496501 matter from the SJC, and my position was that this juvenile offender was entitled to an individualized determination about whether he should be on the registry, and that was how we litigated it in Superior Court. Obviously, since we litigated it there, that case came out. I included all that in my brief because I wanted to make sure I absolutely didn't waive something, but I do think that at the end of the day, the 496501 case, sorry about the numbers, answers the issue that I presented, which is he is entitled to an individualized determination about whether he should be, there should be internet dissemination in his case. He did not get that. That is beyond dispute. The hearing examiner mentions nothing about that. Granted, he did it before these cases came out, but there was not that individualized determination. I think this court must remand it for that determination. If the court does do that, and the hearing examiner then, has a hearing at least on that issue, obviously I think we should remand for more stuff, but just on this issue, that will satisfy my concerns that a one-size-fits-all application is unconstitutional. So I just wanted to.
But we don't remand in every case, do we? In fact, the case that you referred to gives us the opportunity to review the record ourselves and determine whether or not that there would have been a substantial basis for such a finding, right?
No, agreed. And so at least working under that framework, I do think the court does need to remand it in this case, though. And I think it needs to.
And why is that?
Sure. First of all, because I think that would then maybe trigger some of the constitutional problems. I don't think this court can, in the first instance, be the court that makes that determination, that individualized determination for someone, for a juvenile offender. But within the framework of 496501.
Well, as I understand the case law, though, counsel, it's not that we're making the determination in the first instance, but that we can review the record and findings of the hearing examiner and reach a conclusion that it is unnecessary to remand because the law does not require a remand, right?
Correct. Under I keep saying the number, sorry, under 496501, that's correct. That case, however, was not specific about what processes do a juvenile. That was just a statutory interpretation. The statute requires it. As this case came up through Superior Court, there were constitutional issues raised that, at least at the time, I thought might be litigated in this court. I think a juvenile offender has to have a little more process. He's due a little more process, as I argue below. And for this court to make that determination, even if it's
process with respect to internet dissemination or process generally?
No, I'm talking just on the internet dissemination issue right now.
So That the adult cases which say that we can review the hearing examiner's reasoning and the evidence and conclude that even though the order which predates the SJC case may not specifically reference internet dissemination, we may find that implicit in his or her ruling based on the evidence presented that a remand is unnecessary. You're saying that in juvenile cases, the standard is different and that we can't do that?
I'm saying that in the 496501 case, it was just interpreting what the statute requires. I have raised broader issues beyond what the statute requires that I think mandate a hearing examiner, someone who's a fact finder, to grapple with and deal with the issues of internet dissemination there. And if this court now
because this is a juvenile?
Yes, Your Honor, yes.
Okay, so you're saying that all of the cases that we have, and we have several SJC cases and many, many, many Rule 23 cases involving a remand. You're saying those are inapplicable?
I don't know what was raised in those cases. What I'm saying is,
they're not juvenile cases, they're adult cases.
Fair enough. So I'm saying if the court remands it, then it takes care of all of my concerns because he will get that individualized determination at that hearing level.
Well, I understand that. The question is, does the law require that? And perhaps the SJC is going to answer that in the next case that we're awaiting. So maybe it would be better to go on to some of the other issues. I don't know. I was just trying to make sure I understood your argument.
Actually, let me follow up on that, Judge Sullivan. There is a case pending in the Supreme Judicial Court, as you both notified us. Do you think, and I'll ask counsel for SORB as well, do you think it's appropriate to stay the proceedings in this case until that case is released?
I did think about that. I do expect that case, it's been a while since they argued, it probably will come out soon, but it certainly would, I think it would clear up all the issues in this case. So it might make sense to hold off because it also depends a little bit about how they word it, because that case came from the juvenile court, and this is someone who offended as a juvenile who was tried in adult court. And
correct.
I don't know the record in that other case well enough to know if they're applying it. They would apply in a case like this, or it's only implying cases.
Well, generally, I'm not saying we're going to do this. But generally, if that does happen, if there is a stay, sometimes the parties generally ask for one, and then we rule upon it still independently. Then once the case is released, both parties have the opportunity to file a short brief to illuminate the issues of respect to how the case applies to their own case. So you would have the opportunity to read the case and see how it does or does not apply in your view. But I'm going to take it that you're ambivalent. What I'm hearing from you is yes, maybe, but you're ambivalent. Is that fair to say?
My ambivalence, I hate to say, is purely practical because I think that the release of that case is imminent, or would have been, because it's been so long since it's been pending that I don't think this decision would come out before that one.
You're right, except for recent events. So
agreed, and that's where my ambivalence comes in. I think otherwise I would say there's no way to wait. We're on the heels of getting that. Let me say clearly, I don't see a problem with staying. There's no harm in staying the case because it either fixes this or it does nothing, and at that point this court can issue its decision.
All right. Well, thank you for your candor on that. Thank you. All right. And as Sullivan said, let's go on to the other issues.
So I'll pick up on the first issue and what I think is the more substantive issue, which has to do how this hearing examiner reviewed the expert testimony. And just real brief, in case it's not clear, we had an initial hearing where the expert testified, and then on remand, everyone agreed to just adopt the testimony of the expert. So that's why it came in by way of transcript. So that was the record at this hearing, the expert's testimony from the first one. Okay. The hearing examiner rejected the expert's testimony for two stated reasons, and he stated this very clearly. One was that hearing examiner said that the expert uncritically accepted the self-report of my client that he had no attraction to children or no interest in children. And then two, the hearing examiner rejected my expert because he said that she didn't consider the same factors. She viewed her assessment through these juvenile factors and not the more robust factors that the board uses. And he even said, parenthetically, she didn't consider especially the repetitive and compulsive sexual misconduct, which he does not raise at all in his decision. So those are the two reasons he gave.
If I may just stop you on the latter, could you remind me on the repetitive and compulsive piece of this, had he been caught or apprehended either by private parties or law enforcement at any point in the course of the conduct he engaged in with the children?
No, and that's why I think it didn't apply. His testimony, or the evidence as it came out through my client's statement at some point, was that as soon as that he was confronted by the mother of one of the daughters, it stopped. So
Okay.
before he was even charged or came to the attention of the authorities. I now realize by the, sorry, does that answer your question?
That does. So keep on going. We've got you down to 5 minutes, 5.5.
I now realize I've been using the wrong number when I was talking about the internet dissemination. The 496.
We have it. No worries.
Applies to this issue. These numbers always confuse me. So he, the hearing examiner said she didn't use the same factors, which now the correct number 496501 says that's not a reason to discredit expert testimony. She was brought on to consider risk to reoffend, nothing else, not all of the factors that SORB has to consider, but risk to reoffend. And she did so. And she did so primarily through the lens of juvenile research, because that's why she was brought in as an expert prior to any changes in the regulations. That's not a valid reason to not credit expert testimony. The second reason he gave also is not supported by the record. So he says that she uncritically accepted his self-report about interest to children. This was his other reason for rejecting her testimony. And yet the record belies that. I had a long back and forth with that expert. You can see in the transcript, and I quoted in the brief about why, what she makes about diagnosis, what she makes about attraction, what she has to say about his offending with children, given that he was a juvenile at the time. And she doesn't just say, well, he told me he's not interested, and so that's that. She goes into detail about why you don't make these kinds of jumps or assessments with juvenile offenders, because they're different. And she talks about it with respect to the literature. She talks about it with respect to psychology. By no means does she critically accept what he said. In fact, she almost didn't care what he said. She made her own assessment based on literature, based on psychology. So that reason for rejecting her opinion is not supported in the record whatsoever. And so the only two reasons he gave for disregarding her opinion are two reasons. One, by law, is not a valid reason, and the other is not supported in the record. So he should have given her opinion the full credit it deserves, is that if those are the only things that were stopping him from doing so. And he articulated no other reason for not.
You say he rejected her opinion. I mean, her own opinion was that he poses a low to moderate risk. Her response, the hearing examiner ultimately comes out at moderate risk. I don't see it's not a complete rejection of the opinion.
And I wish it was a little clearer in the record, but as I read her assessment and what she was saying, so she is evaluating a juvenile offender. And so she talks about general principles, first of all, which is juvenile offenders have low risk, low recidivism rates. She then talks about when she then evaluates someone, she wants to compare that person to other people like them. And she talks about why she used this instrument, the eraser that they're talking about. And so the eraser is an instrument that evaluates juveniles. And in that instrument is where she gets this terminology low to moderate. And so what she's essentially saying is within the universe of juveniles who already have low recidivism rates, my assessment of him is that he's a low to moderate juvenile offender. So he's essentially a low to moderate of an already low group of people. That's why there was so much of a discussion about why she's using these instruments, why rely on juvenile literature and assessments when we're talking about this person who at the time of the assessment wasn't a juvenile.
Go ahead.
One possible interpretation of the hearing officer's findings is that while everything, and he treats them rather extensively over several pages of the decision, that her testimony is very interesting, but SORB has its own research upon which it has based its own regulations. And that in considering her testimony, he has decided to go with what the SORB regulations say rather than break new ground with her testimony. Why is that? Is that a fair reading? And if so, why would that be wrong?
I think that's a fair reading that makes it wrong. Meaning, if she is a credible witness, if you discount the reasons why he said she's not credible, then she is providing expert evidence, other evidence that SORB can and should consider. So just because
he doesn't have to, though, right? He doesn't have to agree with her.
If he doesn't agree with her, he has to give reasons why he doesn't agree with her that are supported by the record. And so the two reasons he gives for not agreeing with her are not supported by the record, then he kind of has to agree with her, because he hasn't given a reason why he finds her not credible. He hasn't said she has a bad memory. She was stuttering when she testified. She couldn't remember, he hasn't given a reason supported in the law or fact why he doesn't find her credible. As my time counts down, if there's any other questions, I'm happy to take them.
Seeing none from either side, thank you very much.
Thank you.
Counselor?
Morning, may it please the court. John Bossé for the Sex Offender Registry Board. Respectfully, the hearing examiner did properly consider Dr. Quinona's expert opinion, and the hearing examiner properly rejected. As mentioned in my brief, and as Justice England pointed out, the hearing examiner simply disagreed with Dr. Quinona's that the appellant poses a low risk to reoffend. But he did give adequate basis for rejecting a low risk opinion, and that he was required to apply the regulatory factors that distinguish between adult offenders and juvenile offenders, and are supported with adequate scientific citations.
What do you say to your brother's point just now that the second reason given for only finding the opinion somewhat persuasive is it appears to be shaped through analysis of risk factors identified in scientific and not based upon the more comprehensive statutory factors, especially repetitive and compulsive sexual misconduct. Repetitive and compulsive sexual misconduct is not explicitly called out. At least, I have to admit, when I first read it, I thought it was, but as I go back, I don't find it being called out. Is that a...
You make a great point, Justice Englander. The hearing examiner never applied factor 2 because under the regulations, again, which distinguish between juveniles, he couldn't apply factor 2. So I don't know why he mentioned, I don't know why the examiner
regulations say that factor 2 doesn't apply to a juvenile?
That's correct, unless the juvenile continues to offend after being detected as sanctioned. Now, for an adult, the regulations state that repetitive and compulsive can apply at the threshold, regardless if there's a sanction or detection, and then increased weight is given if the individual continues to offend after being sanctioned and convicted.
Well, but even on the adult end, they need to have been caught by someone, right, at the lowest level. Otherwise, it's not compulsive.
Your Honor, at the adult end, even if they aren't sanctioned by a civilian or law enforcement, repetitive and compulsive can still apply under the regulatory language if there's evidence that the offender had the time and opportunity to reflect on his misconduct between the sexual episodes. And the other reason that the hearing examiner gave for rejecting Dr. Quinona's opinion was that Dr. Quinona said that there's no indication that he has a sexual attraction to adolescents. And I apologize, I'm paraphrasing from Dr. Quinones, but I think that was proper for the examiner to state that, because over a period of 20 months, this offender sexually assaulted 2 minor female victims. And then after his sex offending, he was incarcerated for 4 years between 2011 and 2015. So at the time of the hearing in 2017, I don't think it was correct for Dr. Quinones to say that, to reject that all of a sudden the appellant has no sexual attraction to children.
Isn't your brother right, though, that given the case law that's come down since the briefs were written, since the hearing examiner made the decision, that we ought to remand for a specific finding with respect to whether in this particular case there should be internet publication?
Well, as this court knows, it does have the discretion. And in some cases from this court, they have remanded it. But in other cases from this court, they have adequately reviewed the administrative record and determined that a remand is not necessary. And I believe a remand is not necessary in this case.
What are the factors that lead you to decide that?
Sure, Your Honor. The first is to look at his sexual misconduct that took place over a period of 20 months. The next is that he was incarcerated for 4 years.
But none of that misconduct had to do with the public. That misconduct was all at home with members of an extended family, right?
Mm-hmm. Right, but
isn't that a factor that the courts even identify as relevant to the question of whether there should be publication? Whether the offenses were against members of the public as opposed to in a family setting?
I don't believe the courts have gone that far, Justice Englander. What I believe is that, with respect to internet publication, the purpose of internet publication is to put members of the public on notice. So in this case, internet publication would serve a public safety interest, because if the appellant were to get into a relationship with a woman who has minor daughters, they should be able to have knowledge that this individual sexually assaulted 2 minor females over a period of 20 months. And then additionally, he was in the House of Correction for 4 years between 2011 and 2015. And what the Supreme Judicial Court case from 2019 that we refer to it, the explicit findings case for internet publication, what they said is that in determining dangerousness, the hearing examiner can consider the fact that the offender has not had the opportunity to commit contact offenses because he has been subject to incarceration without access to vulnerable victims. Additionally,
would the rules be different for juveniles? And if so, well, let's just start there. So these offenses occurred when he was 16 and 17 years old. And the question before the hearing examiner was, and the question that's now being raised before us, is whether there should be some kind of special findings made with respect to whether it ought to be published on the internet. There are a lot of other contexts, and I don't have the complete list in my head by any stretch, where we're very careful about information about what occurred when someone was a juvenile, right?
Mm-hmm.
I know that we don't, in respect to juvenile criminal cases, they aren't identified by name. It would seem to me those concerns are at least relevant to this question of internet publication, and suggest maybe the rules should be different for juveniles. What do you say to that?
Sure. I believe that there should not be a distinction between the adult offenders and juvenile offenders when it comes to dissemination their registry information, because the due process rights that this state does afford to all sex offenders, including juvenile offenders, and that they have a right to, unlike some of the cases from the other jurisdictions that Attorney Tennant mentions in his brief, and then I mentioned in my brief, our classification system is not based upon a tier-based system. We have adequate procedural due process protections to sex offenders, and I compare the classification scheme for juvenile offenders to the Diachenko case that I cited in my brief, and that the SJC stressed that, just because if a juvenile is convicted of first-degree murder, he should be entitled to a parole hearing in which he has an opportunity to show that he's been rehabilitated. And that's what takes place in the SORB classification hearings. Both parties have an opportunity to—
There's no individual determination with respect to whether or not to publish over the internet. The law would require it going forward after the date of the case that came down last year, but doesn't in this instance. So there's no individual determination. It's much like a tiered system. It says once you're at 2, you're going to get published. And it seems to me, with respect to a juvenile, that there's cases out there that might suggest that some more individualized consideration is required. No?
Well, because the juvenile, because the appellant in this case did have an individualized classification hearing, this court does have a administrative record to review, and it can exercise its discretion on whether internet publication is proper and serves a public safety interest.
Counsel, just by way of background for when we do at least one day get the SJC case. I noticed in the statute that the board can call for a reevaluation of someone's level designation, and the police or the prosecutor can. What procedural protections do the statute or the regulations give to the juvenile to request a redetermination?
Sure. So
in less than 20 years.
Justice Sullivan, for all offenders, adults and juveniles, 3 years after their final classification decision, they have the right to petition for a lower classification. And in
Right.
2018, I apologize.
No. Is there a time after that though? Or is it just a one and done at 3 years?
Oh, every 3 years.
Every 3 years. Okay,
Yeah,
thank you.
and-
Well, I'm embarrassed to say that I couldn't remember the rule. And thank you very much.
I was going to say every
learned
3
it too.
years, and then the burden is on the SORB to show that they continue to pose a certain risk to reoffend and degree of dangerousness. And if they're indigent, they're now entitled to public counsel.
Okay, and remind me, is that 3 years in the statute or the regs?
That 3 years is in the regulations.
Okay, yeah.
Yeah.
I reviewed the statute. I hadn't gotten to the regs yet. Thank you.
The other thing that I would like to mention about the appellant's argument that internet publication is unconstitutional as applied to him, it's interesting that if the Supreme Judicial Court does determine that internet publication that registration is unconstitutional for juveniles, I think this case presents an interesting scenario in that, unlike
He was
the case
adjudicated as an
before-
adult.
Yes, so for purposes of classification, the SORB treated him as a juvenile, but under the sex offender register law, he's an adult because he was convicted of his sex offenses. Of course, the Superior Court had jurisdiction at the time, and no longer has jurisdiction over somebody who's under 18. So I think that's interesting.
Yes, it is. Can you
And
tell us,
do you
Go ahead.
Go ahead.
No, I was just going to ask whether or not you had any strong opinion about whether or not this case should be stayed until such time as we, the case pending before the Supreme Judicial Court is released, one way or the other.
Yeah, I don't, and my honest answer is because there's no injunction in place. So the appellant's information is currently being disseminated as a level 2, including on the internet. But
now, can that ever be retracted? Let's say, for example, we remand, and let's say hypothetically that the hearing examiner does not have any particularized reasons for it. How does that get retracted as a practical matter?
Right. So if I understand your question, SORB will remove the appellant's registry information from the internet and stop dissemination. The problem is what appellants often argue is that once it's on the internet, third parties can gain access to the information. So like anything else on the internet, once it's out there, it could be out there for life.
You know, I'm going to take us, maybe you can answer this in 20 seconds. When does it, so if the hearing examiner says you're a level 2, without an injunction, is that then the moment at which the internet publication occurs, or is it after the district court decision? When does it happen?
Yeah, so that's a great question. When I first started with the SORB, the Administrative Procedures Act allowed us to disseminate immediately. And then we had litigation in the Superior Court in which I quite frankly agreed with the Superior Court judge that there should be a 5-day waiting period. So after the hearing examiner issues a decision, the appellant has 5 business days, including the date that the decision was issued, to go into court to ask for a temporary restraining order.
And then after that, it's published?
What was that?
5 days, it's published?
After 5 days, unless the court issues a temporary restraining order or preliminary injunction.
Thank you.
Okay. Judge Sullivan, did you have a question? No. Okay. Well, I want to thank you both very much. You both have delivered very helpful and effective arguments, and we appreciate it. We'll take the case under advisement. Before we close, on behalf of the panel, I just want to say that we hope that you and your family stay safe and healthy during these difficult times. All right. Okay, there we go. Thank you. Good afternoon. Let me begin by introducing the panel to you. I'm joined today by Justice Mary Sullivan and Justice. Good afternoon. Let me begin by introducing the panel to you. I'm joined to. Okay, I was getting some sound back. Maybe one of the two of you had the YouTube channel going, but I don't hear it anymore. I'm going to just start again and just say good afternoon and introduce the panel to you. I'm joined by Justice Mary Sullivan and Justice John Englander. My name is Ariane Vuono. I wanted to inform you that at the beginning of today's session, we paid tribute to Chief Justice Ralph Gantz, and we observed a moment of silence. As a result of our virtual platform, not everybody could participate in that, and I'm sorry that you were not able to be on for that, but certainly his loss is on our minds as we continue on with our work today. I'm going to now call our last case that we have on the list, which is case number 2019-1826, Jacqueline Owens versus Jonathan Bedard. 2 or 3 preliminary comments. We may experience some technical difficulties during the course of the argument. If we do, please be patient, and we will also be patient with you. And a brief reminder that the same rules of appellate procedure apply to a remote hearing as they would as if we were in the courtroom. You each have 15 minutes, and there is no rebuttal. You can be assured that the panel has read everything and is prepared to hear your arguments. Now, if I'm not mistaken, it's Attorney Owens, who represents Jacqueline Owens, who is the appellant in this case, correct?
That's correct.
Okay, please begin your argument.
Good afternoon, Your Honors. May it please the court. My name is Jason Owens, and I do represent the appellant, Jacqueline Owens. Full disclosure, who is my wife. I think that's been noted here and there and in the records, so to erase any confusion. This is an appeal of a judgment of modification of child support that was entered in the Essex Probate and Family Court on August 8th, 2018, as amended September 20th, 2019, and is also subject to a cross appeal by the father, Jonathan Bedard. In presenting and reviewing this case, I've sort of broken this up into two parts. I think there's the part in which mother is seeking an increase in child support, which is a fairly fact-driven analysis of the actual evidence entered at trial. And the second part is father's counterclaim to decrease child support, which turns more on the law and on burden of proof and some of those issues. And the reason I'm sort of separating them is something I'll get to a little bit later, which is mother is prepared to waive the increase in child support on remand if a remand is necessary for that. If the court finds that father didn't meet his burden to reduce child support. So in other words, if the child support order of $550 a week stays because he didn't meet his burden, and the only way to determine an increase would be a remand, she would waive that remand because she really wants to bring this litigation to an end. If the whole thing is remanded, she'd reserve her rights. So that's one of the reasons why I'm sort of separating this into two different categories.
So just let me be clear, we're talking, I want to be clear on the procedural history of this case. We're talking about an initial complaint filed by the mother in April of 2015, is that right?
That's correct.
The counterclaim to that complaint is the one in which the father sought a reduction in child support. Okay.
That's correct.
All right.
I'm going to start with the father's request to reduce child support. And, you know, this is a case in which the trial court reduced child support by a factor of almost 4, from $550 a week to $145 a week, and then reduced the $145 a week with an additional retroactive child support order that ultimately resulted in a net child support order of $60 a week after the retroactive.
Again, just not to interrupt you, but again, to understand, the retroactive order, that did not go, that was not retroactive past April 2015, was it? In other words, the retroactive child support order that your client, the mother is responsible for, did not go back to the original stipulation that was filed for $550 per week, correct?
That's correct. I believe the retroactive order is actually only from the date of father's counterclaim forward. That's the period of time. It's a $55,000 retroactive order that the court reduced.
And my very last question, which is procedural only, and I apologize, and that is that when the initial child support order was entered for $550 per week via stipulation, there was no calculation with respect to child support under the child support guidelines at that time because the parties had stipulated to that amount. Am I right about that?
That's correct, Your Honor, that there wasn't a finding that the order was consistent with the guidelines. There was one worksheet provided to the court, but there was, in fact, if you listen to
That's fine. You can go ahead with the argument now. I just wanted to be sure that I had those things straight. Thank you.
This case, it largely turns on the trial court judge's apparent belief that the burden of proof for establishing self-employment income for child support, the judge seemed to believe that lay with the party who's challenging the self-employment income rather than on the self-employed parent. And we know this in part because the judge's findings, number 174 and 175, says neither party performed a forensic accounting of the other's reported financial information, nor did any experts testify at trial. Accordingly, father's reported gross income on his federal tax returns in his financial statement is credited. So in other words, because the mother did not retain an expert to challenge his reported self-employment income, the court simply entered it uncritically without making any findings.
That puts a lot of weight, counsel, on the word accordingly, because if the word accordingly weren't there, the two findings would not necessarily imply what you say. And there are other findings where he generally credits the father's testimony on a number of subjects having to do with his income, right?
That is true, Your Honor, but the Whaling case and the cases that have been entered since that requires specific findings of fact regarding whether business expenses are reasonable and necessary to produce income. In fact, the Whaling case very specifically criticizes the kind of general finding of credibility that applies to all expenses and all representations by a party, and actually requires that a judge enter specific findings for those expenses.
You have a list, counsel, of expenses that you raise on appeal as having concerns about. Cost of goods sold expense, there are a couple of others. How was that concern argued to the judge below?
So I think that the argument made to the judge below was presupposed that father had the burden as the self-employed parent to establish that each of these expenses was reasonable and necessary. So at trial, each of those areas was subject to cross-examination. So for example, the $100,000 a year in cash that he gave to his wife to bring to Cuba, father was cross-examined on that. And about the fact that he didn't bring any records to corroborate that this cash was spent on actual business expenses. There wasn't any invoices from his clients showing that it was passed on. And so the idea at trial was that he will have failed to have met his burden that that expenditure was reasonable and necessary for the production of income. And the same holds true for each of these expense categories, because
as I understood that answer, though, it was presented through cross-examination. Was there also a post-trial brief of some sort that made these same arguments?
That's correct, Your Honor. There was proposed findings of fact that were prepared and filed by both parties that made these arguments about the particular business expenditures that were claimed on father's financial statement.
Counsel, were those proposed findings of fact docketed and made part of the record, or were they simply submitted to the judge?
They were submitted to the judge. I do not believe that they were docketed and made part of the record.
Because that is a bit of an unusual practice, I think, in the probate court, where and if they are not docketed, may we properly consider them?
And I think it's a fair question. All I can say in response is that the court on the record requests that these findings be submitted by a deadline, and both parties did that, and that's the common practice. My understanding is this is largely just a matter of the case file being in the judge's lobby and the post-judgment filings going directly to the court or to the judge's office and not being docketed. But there's really no question that the court asked for them and considered them.
Well, see, here's the reason I'm asking the questions, and it sounds to me like maybe the other members of the panel have the same concern. The judge doesn't appear in his findings to have addressed directly questions regarding the appropriateness of business deductions. And when you see that and you see the argument made on appeal, the first question you have in your mind is, why aren't they addressed? Was the argument made to him below that you're making to us now? So is there some place you would point me in the record other than the cross-examination where this argument is made?
And not to correct you, but just so for the record, Judge Elwood is a she, not a he. Now, in front of me, so within the record appendix, it's my memory that the proposed findings of the parties were included. I can check on that and make sure that they were, but I'm confident that each party's proposed findings and rationale was part of the record and was presented in the record appendix.
Okay.
And that would include each side's essentially their closing argument. I don't believe a closing argument was made at the trial, which is commonly the case in probate court trials, is that they don't ask for a closing argument in which each side sort of summarizes the evidence and makes their analysis and argument on what was presented. But that is presented instead in the written proposed findings and rationale. And I can assure you that, there was a detailed critique of what was presented. And so, as I was saying, Your Honor, there is an obligation on the court to enter these specific findings. This wasn't done. Whether we want to say there was a intentional shifting of the burden to mother as the challenging party, or if it was just incidental, the reality is that in these findings, the trial court judge is saying, because she wasn't presented with expert testimony about father's spending, she was just simply going to uncritically report what he has listed on his financial statement as his income.
Let's strip this down to just kind of some simple, basic first steps. The father files a financial statement. In the financial statement, he says, my costs of goods sold are X, in the hundreds of thousands of dollars. May the judge accept, under Whalen, may the judge accept that statement under pains and penalties in the financial statement as fact?
I think the argument is no. I think that at a minimum, there must be testimony about the purpose of the cost of goods sold. And I think what Whalen really says is that this is especially true in a modification case in which the party is trying to seek a reduction in child support based on new expenses that didn't exist at the time of the original order. And we see in Whalen, there's a criticism of the fact that the court didn't examine critically increases in expenses that had occurred since the time of the judgment and the time of the modification.
And when you say examine critically, do you mean in terms of the bona fides or the legitimacy of it, or the dollar amount, or both? In other words, what level of proof are you saying that the proponent of a financial statement has to make when there's what are essentially closely held businesses here and a significant integration between personal and corporate finances? What level of proof are you saying is required, either by way of testimony or further documentation, before a probate court judge can say they have satisfied their burden in this respect and I adopt it?
So I think that there's a burden to demonstrate both the legitimacy of the deduction and the amount. In our case, in this particular case, there's not a challenge as to the amount of the cost of goods sold. But I would say that in a case in general, that there is a burden to demonstrate through, at a minimum, bank records showing deposits that can be traced back and analyzed as to match up with the dollar values of the claimed expense. But okay, I think the first threshold matter is whether or not the category of expense is legitimate. So was this an actual business expense? Is there evidence in the instance of a cost of goods sold that it was passed on to a client?
So let me play devil's advocate with you. Did you request any of that information in discovery?
Yes, in fact, there was a request for documents, and there was a extensive discovery process that was conducted when the father was using his 2015 income as representative of his income for child support purposes. And what happened in this case was that on the first day of trial, he showed up at court with a financial statement that provided his 2016 income as what he termed his current income. And that was the first time that mother had seen the 2016 income presented. So there wasn't an opportunity to analyze this ahead of time.
Trial started, was the mother still living in Swampscott and under some kind of restriction that she could not move to Hingham?
Yes.
And so it was incumbent on you to have the trial move forward. Is that right? Because the relief you were seeking was that she could move.
That's correct. It was incumbent to have the trial.
Even though you could have raised an issue with respect to the late discovery, you had another problem.
Well, I think the issue
Do you understand what I'm saying? I'm
that,
just
that the trial had to go on.
Yeah.
Yes. And I don't think that there's any denial of that. I think that the fact that the judge seemed to require expert analysis, a CPA, to analyze father's income was certainly complicated by the fact that he did not announce or provide any documentation relating to his 2016 income until the first day of trial. So it was after discovery had closed. That was objected to at the time, but the court allowed it to proceed. And our arguments are made on what was actually presented, which was allegedly the 2016 income. He did not support that with the 2016 tax return, even though the trial started in June of 2017 after that tax return would have been prepared.
Actually, I see that your time is up. It's sometimes difficult to follow in this format. I'm going to check with the panel to see if they have additional questions. I don't see any. I want to thank you for your argument and be assured that anything that you did not address that's in your brief, that it's not been waived, it's in your brief, and we will still consider it. Okay. All right. Okay. Now I will now return to Attorney Babro. Am I saying it correctly?
You are. Thank you, Your Honor. Good afternoon. May it please the court. To summarize the petitioner's argument, my brother's argument, I would look at page 39 of his brief. He states, he uses a specific quote, and he states that examples that the court found, yet the court did not independently view the evidence. What he's saying by that is, I'm frustrated that the court did not accept what I believe to be true. That's the summary of the petitioner's argument in this matter. They are not happy with how the court accepted the evidence that was presented before it. Let's talk about that evidence that was presented before it. If I was standing before you, I would pull out approximately 1,000 pages of transcript, 4 days worth of testimony. Father testified in all of them, subjected to cross-examination. In fact, he was called as a witness by mother's attorney. I would also present volumes of discovery that had been provided, volumes, credit card statements, bank statements, transactional statements. We are not talking.
2016 tax return provided?
2016 tax return is not part of the record.
Okay, and is it correct that the 2016 financial statement was provided on the day the trial began?
I was not the trial attorney. That's what my understanding is. My understanding is also that there was not an objection to that. And going to your question before, if that was presented and that was so important, if that was so important to the petitioner's case, they could have asked for a bifurcated hearing. They could have asked for a hearing on the removal process and asked for a separate hearing on the financial process after they had time to review those statements. Why would it be incumbent upon this court to look later to make a determination as to what factual issue should or should not have been presented at that point in time? It was presented and it was cross-examined. There was no objection to the record on the hearing going forward with that information.
Did your client provide, so you in your brief, thank you, put in 2 summaries of financial information. The first one was the 2015 summary, and the second one was the 2017 financial statement summary. In the 2015 summary, there's a line item for cost of goods sold of $303,000. $309,000, pardon me. And that's, I believe, on an annual basis. And then in the 2017, I'm looking at page 11, I see 2 items of cost of goods sold totaling $90,000 a month, or over $1 million a year. Was there evidence presented by your client as to what the basis was for those deductions against business revenue?
You referred to page 11. Are you referring to page 11 in the brief? I'm not clear.
11 and 12 of your brief. So cost of goods sold on page 11 against financial statement A is $55,000.
Okay, I see.
Cost of goods sold against the second component of financial statement A on the next page is $35,000. Add them up, it's $90,000 a month, or over $1 million a year in cost of goods sold. Seems like an extraordinary amount of money to me to not have an explanation in testimony. Was there such an explanation in testimony?
There was the general testimony explanation. He testified, again, he testified for 4 days, and he testified specifically about what each of his businesses, what the goal of each of his businesses, the product of each of his businesses, and how each of his businesses created revenue and how each of his businesses had expenses. That was the entirety of his testimony.
So what was the $1 million in a year of expense for cost of goods sold? How did he explain that?
He explained it in multiple different areas. Part of the problem is that we're dealing with multiple different businesses. So it's not just one business that we would be referring to. And this is how I'll explain the difference between this and the Whalen case. It's not just one business. He testified onto multiple businesses, including Cuba to Go. He had.
So let's take Cuba to Go.
Sure.
What were the costs of goods sold for Cuba to Go that he testified to?
He had multiple different costs for Cuba to Go. I guess I'd be looking for a specific cost, because the way
I'm looking for an explanation for $1 million in expenses that were taken. And I've read Whalen, and it seems to me that some sort of explanation should have been in the record. And it seems to me that counsel, when the issue has been directly raised by appellate argument, ought to be prepared to explain that.
So if I can respond, and I'm not trying to avoid your question, I'm responding in a general sense, because in terms of how the trial testimony unfolded, if we look at what Whalen says, Whalen said specifically, they took the information. If I'm looking at page note 15 under Whalen, the testimony was, at trial, the father testified that he deducted his gross weekly income from those types of business expenses, which he had deducted for tax purposes in his 2006 federal income tax return. We earlier observed that father's income from self-employment was determined solely on the basis of his financial statement. Can we say that that's the case here? His income was determined solely on the basis of 5,000 pages of discovery on 4 days of testimony.
It would be very, we've heard your reference to that, but the question that's being asked is far more specific, which is simply describe to us the evidence which shows what those expenses were and why they were legitimate. Just tell us the story.
Okay, so for example,
what they were.
For example, the court found, I can't point to one specific example, because the court found multiple different examples. For example,
start with one.
There was testimony
to others.
There was testimony regarding Mr. Bedard providing to his wife cash for purchasing goods and products. That was one of the issues that was raised. I'm sorry?
So that's $95,000 in cash. What goods and what products were purchased for that?
There was testimony.
Several categories, counsel. I'm just trying to understand a little bit about the businesses that we're talking about, because pardon me, but when you see numbers of this amount on a person, on a closely held company, $1.6 million in revenue in a year, the notion that that person is not making any money, or maybe making $70,000 a year, seems a little bit unusual. So let's take the $95,000 for Cuba to Go that were given to the wife in cash. What types of expenses were those applied against?
So those type of expenses, so I'll refer to factual finding 160. Rosalind works for this company and receives a paycheck. Although Rosalind's credit cards can be paid for with funds from Cuba to PARKPOOM.com, she uses the credit cards to purchase goods for the company, and only her business purchases are deducted for income tax purposes. If this court is suggesting that she would then need to come in and testify and state specifically what each of those purchases are for, that did not occur. But could that ever occur in any hearing where you're talking about a major self-employed issue? Could this ever occur? Would you go through and itemize every single dollar that the business
Counsel,
spends?
we're not concerned with how bad it could be right now. We're just concerned with this case. And I think what we've been asking for about the last 5 minutes is a general description of what goods were purchased and how they related to the corporation.
And
can you point us to the transcript where your client testified about that?
Well, unfortunately, I would point you to the entirety of the transcript, because the transcript isn't testified. There is not a singular means. There's not one point in the transcript where he's testifying on to this issue.
This issue is about the burden of proof then, counsel, because surely it is not, if the burden of proof is on you, it is not an adequate response to say somewhere in that 4 days of testimony is what we proved. That would be inconsistent with our appellate rules. As I hear that answer, I'm starting to think that at least there's something to what the appellant's counsel said when he said this is about the burden of proof and who has it.
I guess the only way that I can respond to that is to cite what the court's findings were, because if I'm going to,
they're very general. What business was Cuba in, and what was she buying?
Okay, so Cuba to do is a travel agency, effectively a travel agency that allows people to travel to Cuba.
Okay,
so
what was she buying?
So numerous things that she would travel to Cuba to purchase would include advertisement, would include hotels, would include all of those things that you would do if you are having people go to Cuba and you're setting up effectively travel for them. That's
so $95,000 a month in advertising and hotels?
Those are two examples. The two examples would be hotel. Another example would be pre-purchasing, obviously, food packages, hotel packages, tourism packages. These are the type of things that she would spend money on.
And did your client testify to that?
My client testified in a general sense. He testified.
I don't understand what that means. Did he testify to what you just said?
So he didn't specifically, there's nothing in the testimony that specifically references that. He references specifically that money was expended on these issues, advertisement and other things that would be necessary for the business.
But a lot of those things are separately itemized. You have costs of goods sold, and then you have separate itemization of some of these things. I mean, for example, if you look at the CubaToDo.com, you'll see cost of goods sold of $309,000, and the next line is advertising, and the next line is contract labor. So, there's a line for travel. So maybe some of this $300,000 was she went to Cuba and she bought hotels in Cuba because that's the way you had to do things. We're asking the questions because we've read Whalen and we're concerned about what proof there would have to be to establish the expenses against a self-employed business.
I'm not disagreeing. I certainly understand what the court is stating. My point is that this was done and this occurred at the trial court level. To suggest later that these are questions that should have been asked, that would be, to me.
Well, let me put it this way. Maybe there weren't questions that should have been asked. Maybe it's evidence that you should have produced. In your view, who did have the burden at this trial?
Well, that was raised by my brother. And the reality is, if somebody comes in and testifies and states, I'm spending X amount, and they are subjected to cross-examination, and the court finds that that is credible, is it the suggestion that they need to then break down and say, I'm spending X amount, when they've also provided discovery to support what their testimony is?
Well, excuse me, partly they may be a question of who had the burden of proof. And in your view at this trial, who did have the burden of proof?
Clearly, Mr. Bedard had the burden of proof, and clearly
Because it was her complaint, even though it was your complaint, and you also filed for modification in
I
terms of
thought
the
he said
counterclaim.
Mr. Bedard had the burden of proof.
Mr. Bedard, father has the burden of proof.
Oh, I didn't understand. Thank you.
I would agree with that. And father sustained his burden of proof. And how do we know that? Because the court specifically states they found his testimony credible. They found from factual findings, 132.
Where does the court say, I find his testimony credible with respect to the expenses deducted against income for his businesses?
In 4 different areas, the court between factual findings 132 and 160, the court references finding it generally credible, or the court says father is credited, which I'm going to assume means the court finds that statement to be credible.
I haven't found it yet. I'm still trying to find where you say that. Like, for example, 135, father was credible regarding the structure of his businesses and how money flows. That is not finding father was credible as to the business expenses for his businesses. Where is it? It may be here. I just haven't found it yet.
Sure. So 136, father's income as reported on his income tax returns and financial statements is generally credited. I'm going to assume that she is saying she finds that credible. The financial statements would outline the expenses that this court is asking for and referencing. If we go to 139, the court finds reported on his financial statement, gross weekly income, and federal references exactly what this court stated, that father's 2016 federal income tax returns were not in evidence. The court further goes through and acknowledges and states specifically what father had testified to, exactly what we just talked about. Under 160, Rosalind works for the company and receives a paycheck, talks about the credit cards. In 159, Cuba de Goo's bank account shows deposits, the amount that it was deposited. The court goes through this in multiple different areas in terms of what was presented for gross income and what was presented for gross expenses. The reason we know this is nowhere in the petitioner's brief are they challenging father's gross income. Why would they?
No, we're not talking about gross income. We're talking about expenses.
I understand.
I don't think anybody's going to have a problem believing that there were $1.6 million in gross income in 2016. I mean, one would think that there might be enough to pay child support out of that, counsel.
Well, I don't.
It's greater than $60 a week.
I don't think that there's anybody that he was never, ever. The order is not for him to pay $60 per week. The order is simply that there was a retroactive application of overpayment. So there is no, I understand that it's well and good to state that with all of this money coming in, he's only paying $60 per week, but that's not the order. The order is that he's paying more, but that he overpaid for a long period.
Can I ask you, I have another question, unless I'm jumping ahead of Judges Sullivan or Vuono.
Go ahead.
In findings 152 and 153, the father's expenses totaled $6,982. Is that a weekly expenses of $7,000 a week?
You're talking about for overall overarching for the businesses?
Well, no, I'm looking at the finding and I'm trying to, that was going to be my next question, but I first wanted to make sure that I'm correctly identifying the numbers in 152 and 153 is showing over $300,000 a year in expenses.
That's good. That would coincide with the testimony. That is correct.
Okay. And are those his personal expenses or are those his business plus personal expenses?
So I read this. I read that there was the amount of business, the amount of expenses that they're referring to in this, because they're talking about child support payments and legal and parenting coordinator fees, would be personal expenses because they're talking about personal expenses.
That's what I assumed it would be. So somewhere there's some financial statement showing that father was had personal expenses of over $300,000 a year. And mother's personal expenses were roughly $40,000 a year. Is that right?
That would seem to coincide with the financial statements.
But is it the contention of the father that they had equivalent lifestyles? or
Well,
that their life.
You can have a high amount of expenses and have an equivalent lifestyle with someone who has fewer expenses, depending upon how those expenses are created and what those expenses are for. I'm assuming, especially based on his testimony, that a large amount of his expenses, even though they're personal in nature, have business correlation. For example, individual travel could involve individual travel for his own personal benefit, but also for his business benefit.
Well, no, you can't mix personal and business and then ask someone to understand it. I mean, it's either his personal expenses or his business expenses, or they're together.
I'm not disagreeing that you can't do that. What I'm suggesting is that there are situations where they are overlapping, where they intermingle. The question would be whether those expenses were ever used.
Accurate records for federal tax purposes so that you don't intermingle those. As a general rule, that's my understanding, at least. Is that yours?
Oh, I would agree. And this is also someone who has filed his income taxes, and there was no testimony presented that there was any issue with his income taxes.
Right. I think that Justice Englander has no more questions. Justice Sullivan, no more questions. I don't have any either. I want to thank you both very much for going over your time and answering all of our questions. We had many, as you can see. It was an effective argument, and we appreciate it. I'm just on behalf of the panel, before you leave, we hope that you and your family stay safe and healthy during this time period. It's a bit challenging. So please make sure that you take care of yourselves and your loved ones. With that, we'll close today's session. Thank you very much. We'll take the case under advisement.